Well, I beg your permission to place an urgent motion before your lordship today, my lord. I am diplomat.
May I please, your lordship, in item number 55, we have filed an affidavit yesterday, my call.
May I please the lordship, my lord, I pray for listing of a motion matter on Friday, my lord.
Well, please, your lordship. I beg to mention a contempt matter for listing. If your lordship may please to list the matter on 14th
You have it next week.
next week, your lordship.
Milord,
Deeply obliged, your lordship.
Milord, motion matter for tomorrow, Milord. Must.
Wait, not tomorrow.
But-
Yeah.
But settlement of market, Milord, I am the house bidder without informing me, Milord, settle the private respondent, Milord.
You want to do it today, you do it today, not tomorrow.
Then today, Milord. Must.
May I please, your lordship, I beg to mention for listing one motion matter for tomorrow, lordship. Lordship, yesterday, I have mentioned this case, lordship. And lordship.
Motion
permitted-
cannot be tomorrow. Has to be today or Friday,
Lordship, then at 2 PM, lordship.
not 2 PM, today.
Deeply.
May I please, your lordship. Lordship, I beg to mention item 34, your lordship. The counsel for respondent number 2, your lordship, for some personnel difficulties, he cannot be appear, your lordship. So,
When do you want it?
your lordship.
Do we take in the permission from the other side?
Yes, your lordship.
Petitioner lordship,
You have no urgency?
because he has some admission, because of admission, he has some personal difficulties. That's why.
There is no urgency?
As urgency, there is a
What is the urgency?
non-payment of bill lordship.
What you are appearing for whom?
I am appearing for G. Pathak, your lordship, for respondent number 2, your lordship.
What is response number 2?
College lordship.
That is North Lakhimpur College, your lordship.
Okay, next week,
Highly obliged, your lordship.
give a date. Yes,
Lordship,
Mr. BP Bora.
Lordship, I beg to mention a matter for motion, urgent matter, Lordship, tender matter. I was deprived from participation. Lordship,
Today?
Lordship, today, if Lordship is convenient.
Lordship, with regard to item number 31 and 32, Lordship, making a prayer on behalf of Mr. P. Sharma, Lordship. Today is his mother's Shad ceremony, your Lord. That's why I'm praying for nature. Have you informed the other side, your Lordship?
31 and 32.
Lordship.
There's no urgency.
Otherwise, Lordship, there is Lordship, but due to the peculiar circumstances, Lordship.
You are for the petitioner?
For the petitioner on behalf of Mr. P. Sharma, Prakash Sharma.
P. Sharma is for the petitioner?
For the petitioner, Lordship.
Have it. 24th.
Lordship.
Yes, Your Lordship. I'm praying for motion matter, Lordship. Motion matter, Lordship. Praying for motion matter pertaining to temporary settlement of Parghat, Lordship. Lordship, may I fix the matter on
When?
day after tomorrow?
Yes, Mr. Bora.
My lord, I don't know whether depending on the urgency or nature of the measure, your lordship will permit it to be moved unlisted. In fact, I filed it 3 days ago, my lord. My junior is giving the memo today during after the motions.
Not after the motion.
Anytime.
Today.
but my junior is giving the memo.
May please, your lordship, non-compliance of the order dated 17/2/2026, lordship, by the confirmed note. Next, one page number 9, start and relevant portion, my lord, page 20, lordship.
What is your allegation?
Well, my lord, allegation, my lord, the license of the petitioner were suspended due to non-distribution of the shares of.
Who are you? Who are you? Now, have you submitted this document to the judgment to the person concerned?
Yes, lordship.
When?
On 2/3/2026, Lordship.
Where is the document?
Lordship, page 9, Lordship.
Yes. Find it out why this has not been done.
We don't have copy of this contempt case, my lord.
So what? Give a copy. You have an extra copy?
No.
This is an application filed for willful and deliberate violation to the order dated, to the judgment and order dated 17/2/2026. Passed by the learned coordinate bench in WPC number 4346/2024. Wherein the learned coordinate bench had directed the licensing authority to proceed from the stage of show cause replies submitted by the petitioners after affording an opportunity of personal hearing to the notices and upon due consideration, it was also directed that after due consideration, the licensing authority shall pass a speaking order in each of the cases of the petitioners by taking into account the provisions of the PDS bracket control order 2001, APDA order 1982, and the terms and conditions of the FPS licenses under the APDA order 1982 on its merits. This court further directed the licensing authority to bring the proceedings in both the cases to a logical conclusion within a period of 1 month from the date of submission of the certified copy of the order by the petitioners to his office. It is seen that the said order was served on 2/3/2026. Further to that, it is also taken note of that the Co-District Commissioner, Lakhipur Co-District, is very much aware of the. Oh, this is another order. On 2/3/2026. This court therefore, requests Mr. So-and-so, the learned. What is your position? Junior government advocate. Junior government advocate. To obtain instructions from the Co-District Commissioner. Why this direction is to here? Why you are making the other person a party? You have served the copy to the Deputy Commissioner and you are making the party is to the Sub-Divisional Officer. How is it possible? Mr. Counsel, can't help you. Withdraw, file properly, or dismiss.
My lord, matter may be taken after some time, Lordship. Matter may be taken after some time, Lordship.
Bye.
My senior will,
Who is your senior?
LR Mazumdar, Lordship.
Huh?
LR Mazumdar.
LR?
Mazumdar.
Where is he?
Another court, Lordship. Another court, Lordship.
Another court. Ask him to come. We dismiss in his hands.
Maybe Lordship, my lord. At this case, my lord, the one municipal room initially allotted by the my lord on Dhaneshwar Nath and Shahidul Islam, my lord. And thereafter, my lord, in 2014, and both the Shahidul Islam and Dhaneshwar Nath vacated the room on because of the construction of the new building, my lord. Thereafter, my the Shahidul Islam handed over the room to the,
Where is your representation?
my lord, page, particular page 25, 24, my lord. Page 23, next 7.
Yes, where did you pay 50,000?
My lord, page 23, my lord.
Huh?
23 page.
Where?
Page 23, my lord.
22,
22 and 23 also, my lord.
not 23.
20, my lord, notice to pay.
Notice to pay was issued.
Yes, my lord, and thereafter we pay, my lord.
Deposit 50% in advance
Ye-
of the
yes,
room
my
rent.
lord,
The
then
remaining will
page
be
22
used.
paid. Will pay, my lord.
So when did you pay?
My lord, 26, 24, 6, 19, my lord.
And then remaining amount?
Remaining also
Total
payment.
is 1 lakh. You paid the 1 lakh.
Our part is 50,000.
Huh?
50,000, my lord.
No, kindly see. Hereby informed the last day of so and so that the meeting
Annex, my
unanimously
lord.
decided to deposit 50,000
My lord, annex
out of rupees 1 lakh in advance of the room rent.
Oh.
The remaining 50,000 will be used to complete your unfinished room. Every shopkeeper will deposit per room and deposit the money in the bank to pay the bill of the contractor concerned. Therefore, it is requested to deposit the amount within 15 days. So therefore, now out of 1 lakh, you have paid 50,000. Where is the remaining 50,000?
My lord, here the one room is allotted for 2 persons.
Total is
Already
1
payment, my lord, that receive.
Total is 1 lakh.
Yes, my lord.
Out of which you have paid 50,000 in the year
Only, my lord,
2019.
my question that
Where have you paid the remaining 50,000?
we paid, but receive is not here, my lord.
File your additional affidavit.
My lord, they are.
No, you have paid.
My
You
lord,
say that
they-
you have paid.
yes, my
Otherwise,
lord,
why
they-
should we ask
my
them?
lord, my humble summons should the instruction will be called, they will be
No,
clear.
nothing doing. That have you mentioned a statement out here that you have made the payment of 1 lakh?
একদম my lord, ভিতর 50,000 we have paid.
No.
Say. My lord, kindly see my final part, my lord.
Pardon,
Yes,
no,
2020, my lord.
I'm not going to look into if you have incorrectly made. Here is a case very
Here,
specific.
my lord,
Total payment required is 1 lakh. You said you have paid 50,000. Okay. What about the remaining 50,000? If you have not made the payment of 1 lakh, where is the question of you being handed over the room? That case. We can't issue a writ. Yes, you have paid the 50,000, remaining 50,000, then they
Lord,
don't pay,
my
then it
humble
is a
sum-
different.
My
Yes.
lord,
My lord, in this matter, Howley Municipal Board, the main party. However, my lord, one room is allotted jointly. Dhameswar Nath is also necessary party here, my lord.
Hey, forget about that. Total payment required is 1 lakh.
1 lakh, my lord.
He says that he has paid 50,000.
50,000.
If he has paid 50,000, why should we issue a writ asking them, why haven't you handed over the possession?
My lord.
Unless you pay the 1 lakh. No case.
we have paid, but money received is not available at present.
It cannot be. Have you made a statement that you paid 1 lakh? That is also not there. Don't come up with these type of things.
I have statement, we jointly payment 50,000 out of
Yes.
1 lakhs.
No.
My lord,
See your representation. That is why I wanted to show you. Where have you mentioned that you have paid 1 lakh?
1 lakh is not payment, my lord.
So we dismiss or you want to withdraw?
My lord,
Dismiss or withdraw?
we further
Either
instruction.
of it.
further instruction we required, my lord,
No
then we file one
instruction.
additional
They don't
affidavit.
Here, they can't produce the instruction. It has to be given by Howli Municipal Board. Why should we issue notice to them?
No, my lord, I, from my client regarding the balance payment, my lord.
Ah, you knew also. Fantastic. Then you also should have told him it is coming before a judge who doesn't like to issue notice
Yes.
so easily.
Hmm.
Have you told them?
Yes, I will in
Ah.
contact with my client whether the remand paid is paid or not, my lord.
Lekhok. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. The petitioner has submitted a representation on 22/7/2024. To the executive officer, Howli Municipality. Seeking, thereby requesting for the purpose of allotment of the room. From a perusal of the notice which was issued to the petitioner on 12/6/2019, it is apparently clear that the total consideration which the petitioner is required to pay is 1 lakh, and out of which 50,000 was paid by the petitioner sometime in the year 2019. The petitioner have not been able to show before this court that the petitioner had paid the remaining amount of 50,000. It is also seen that in the representation which was submitted almost 2 years back, there is no mention, whisper, that the total amount of rupees 1 lakh have been paid. The petitioner has approached this court in the year 2026, after 2 years from the date of submission of the representation. And in the writ petition also, there is no mention that the petitioner had paid the entire amount and therefore has approached and being aggrieved, have approached this court on account of not allotting him the room.
My lord, room was allotted, my lord, but not, room was allotted initially, 2014, my lord.
Now, no, it is not being handed over.
Oh,
The room
handed over,
not
yes.
being handed over.
Yes, my lord.
Under such circumstances, this court does not find any good ground for issuance of notice in the present proceedings, for which the writ petition stands dismissed. Before parting with the record, this court observes that the dismissal of the incident writ petition shall not preclude the petitioner to submit a fresh representation before the respondent authorities, more particularly the executive officer of the Howli Municipality, after payment of the necessary dues, seeking the handing over of the room.
My lord.
Naam kita didi. Yes, Mr. L.R. Muzumdar.
My lord, regarding your lordship, at least one opportunity, I will produce the contact with my client, whether the remand paid is payment or not, my lord.
Go there. After 2024, after 2 years filing a writ petition.
My lord, they are always mentioned we are giving, and the construction was completed 2005 last hour, my
Have
lord.
you mentioned any that you have given us subsequently any representation?
Then, my lord, I want.
Okay, 10,000 rupees cost upon the learned counsel appearing for unnecessarily spoiling the time. Yes, Mr. Muzumdar, how can we issue notice in this case?
Lordship, we have served the copy upon the district commissioner. Now,
Where?
Lordship, he,
You have not served a copy upon the subdivisional officer whom you have made the respondent.
Lordship,
not
now
made
it
the
is, now it is Boko district commissioner.
Whatever may be, the copy was not served upon his office.
But
Whom See the name of the respondent. Read it aloud for the others also to know what type of petition.
Lordship, we have served it to district commissioner.
Forget about that. See the name of the respondent.
It was subdivision of district.
You also understand.
Lordship.
Withdraw.
Lordship.
Mr. L.R. Mazumdar, the learned counsel appearing on behalf of the petitioner, submits that on account of a formal defect, the petitioner would not like to press the instant writ petition. However, submits that the petitioner may be granted the liberty to approach this court in future. Taking into account the above, the instant application stands closed on withdrawal. So the petitioner is granted the liberty to approach this court. In the circumstance, the judgment and order dated so-and-so, passed in so-and-so is not being complied with by the respondents in WPC number so-and-so.
All right.
You, Mr. Mazumdar, kindly ask this person to issue a notice. Because what has happened out here is merely signing would not do. You have to issue a notice because there is a direction from the date of submission of the certificate.
Lordship.
So where is the proof for that? You
Lord.
can't have it on the body of the year.
All right.
What is this?
Non-payment of contractor dues.
Which year?
1819, madam.
Why should we issue notice?
I thought,
1819, why?
yes, my lord.
Anything new has happened recently?
My lord, after submission our representation,
So what?
no
Go
reply.
to the
has been
civil court.
received. Though the work was completed 1890, my lord, formal
You
work.
have issued a notice under section 80, go there. 1819, your work is there, why should we entertain? Isn't it difficult?
But there is a development, my lord.
What development?
After filing of this case, my lord,
Ah.
recently we have received a reply, my lord, from the
Ah.
department, my lord.
What do they say?
And they said, my lord, they furnishing our required documents, my lord.
Then? Oh.
Recently we have received, my lord.
No, all these things are understood, but the fact remains, what was stopping you from 2018 to 2026? 8 years, na?
Yes, my lord.
Why should we entertain? You have issued a legal notice only on 12/2024.
Thereafter, we have also submitted our communication, my lord.
Your completion was then when?
In
Your
1890 also,
completion certificate does not have a date also.
that completion certificate was issued by the quarter holder, my lord. This is basically repairing works, my lord.
So repairing works by whom?
I have done the repair works of the quarter, my lord, the departmental
Whose
quarter.
quarter?
The quarter,
So there is no completion certificate by them. It has to be given by the where's your work order?
yes, my lord. Page number, my lord, annexure 5, my lord. Page number 25, my lord.
Huh?
Page number 25, my lord.
Repairing of so and so.
Yes, my lord. That order was,
The
yes, my lord.
estimate is mounting so and so have been framed to show the probable cost of the work,
Yes,
so and so. Elementary. Name of the, this is the work.
Yes, my
Where's
lord.
the work order?
And this is the only one.
What? Where's your name? Is your name inscribed therein?
Yes, my lord. Kindly see the annexure 4, my lord. Page number 24, my lord.
Page number?
24, my lord. After submission of this representation, they have furnished this property.
This is your letter.
Yes, my lord.
This your letter cannot help you. Where's your work order? No.
They are also not disputing, my lord.
That is the problem. If we issue a notice to him, he would not be able to trace out any, he can't even verify. Why have you approached so late? Why? You have issued a legal notice, go there. It will be construed as a section 80 notice. Go there, not here. Sorry. Now you are having, at the time of filing the writ petition, you are having blood pressure. All these ailments.
This is my mother's document, my lord.
See, the medical report. It is dated 28/6/2026. How is it possible?
It's my mother's document, my lord, not mine, my lord.
So we dismiss it?
No, kindly consider my representation.
No, representation consideration is a very difficult thing.
Then, my lord, kindly grant us liberty to file civil. suit.
Yeah.
Yes, ma'am.
This is an application filed, the present heard so and so party. The present writ petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent authorities in not payment, not making payment of the contractual of his contractual dues to the extent of rupees 2,42,110, which have been pending from the year 2018-19. Full stop. This court have duly perused the materials on record. And from the perusal of the materials on record, there is no. You withdraw. If I have that, you will have an objection. From a perusal of the materials on record, this court does not find that there is any work order which was even issued to the petitioner. Mere submission of representation or legal notice, in the opinion of this court, is not enough for the purpose of entertaining the instant writ petition. More particularly, when the petitioner has approached this court after a hiatus of 8 years. Accordingly, this court does not find the present case to be a fit case for issuance of notice, for which the instant writ petition stands dismissed. So before parting with the record, this court, however, observes that the dismissal of the instant writ petition for the reasons aforementioned shall not preclude or prejudice the petitioner to approach the appropriate civil court if otherwise permissible under law.
Much obliged, ma'am.
Mr. Hawk, what are you doing with Gauhati High Court? What is your case?
Here, my lord, the petitioner, my lord, here is the HS past candidate, my lord.
Huh?
He is HS past candidate, my lord. He was initially appointed as my lord, peon contingency, my lord. Under,
Peon?
yes, my lord.
Then?
Under the establishment of the district and session judge Boanga, my lord.
So what?
In the year 2000.
Now what is yours here? That your representation has been rejected for the purpose of?
That upper limit of qualification, my lord.
Cannot be done.
So this is the case, my lord.
No case.
My lord, here this.
We cannot issue this notice.
My lord, this notification, my lord, does not apply to the petitioner since, my lord, at the time of his absorption, my lord.
What is
initial
this?
engagement, lord.
There is
There are-
one judgment out here. Who has passed
Yes,
that?
my lord.
What
There are
did I
challenges
say?
in the notification, my lord, advertisement, my lord.
Mohammed Ghani, he submitted that limiting here. This court finds it that to take note of the judgment of so and so, wherein a 3 judges bench after taking various judgments on question of limiting the Niman. The perusal of the above shows that it is the employer who has a right to determine and decide the relevancy and suitability. It is there the Supreme Court, while dealing with the aspect of prescribing Iman, graduate shall not be eligible and a candidate must be passed. The Supreme Court observed that the said prescription of Shaya could not have been interfered with by the High Court and permits the appellate therein to allow so and so. Now let this court take note of the next submission so made by the RIAT that there is no way in prescribing the requisite. This court finds it relevant to take note of the Shaya. If justice in exercise. And so, further seen that another notification was issued, was made applicable as regards the eligibility of so and so. Taking into account with it, we seen that eligibility criteria set out in the area which was applicable anywhere in system that the post of area must possess the minimum qualification of Iman and those who have passed HSLC or above having account above and applying the same to the judgment way in the requisite educational qualification. That when in the corner second. So, what to do?
My lord, here, my lord, while the petitioner was initially appointed, my lord, at the relevant time, my lord, there is no bar, my lord, at all, my lord. 2016, my lord, a notification was issued by the Gauhati High Court, my lord, only to just coordinate bench in respect of the appointment of a grade 4 of peon, my lord. Limiting the upper
You were
qualification
appointed already.
I was initially appointed as contingency peon, my lord.
So you want what?
Now I want, my lord, in any.
Regular?
There is another post lying vacant, my lord.
Regular?
Yes, my lord.
Not possible. That
Otherwise,
post
my
has to
lord-
be filled up only by way of selection.
Yes, my lord.
Then,
Regular selection.
and selection, you do not qualify. You have class 12 passed.
My lord, now that is my question, my lord. That
Have
is
you
the submission,
challenged
my
that
lord.
those notifications?
Because at the relevant point of time, my lord,
There
this
about that
appointment, my lord,
before. You don't, you're right. You are asking for regularization.
regulation or absorption in
No.
any post, my lord.
Are you asking for regularization? Then it's a question is different. Otherwise, no.
Regulation or absorption, my lord, in any post, my lord.
Sorry.
My lord,
You
otherwise,
want any other post, go there. Class 12 pass, then you have what post? Driver? Go for driver. No case.
my lord, only thing is that, my lord, at the time of appointment, my lord, see, there are already, I'm submitting, my
Mr.
lord.
Hawk,
I know, I can understand, my lord.
I am very sorry.
My lord, there are some office peons, my lord, who are having, my lord, gazette qualification also, my lord, they are being
Because
arrested,
at
my
that
lord.
point of time, it was not necessary. For the purpose of compassionate appointment, it is not necessary. Do you come
They
under
are-
the,
they were-
do you come within the ambit of compassionate
No,
appointment?
no, my lord.
No.
They are regularly selected, my lord, before, but admittedly, they were appointed prior to this
So what?
2016 notification, my lord.
So what? Now these notifications hold the field.
My lord,
So
it
therefore,
was made effective in the
the
year
representation has been rejected.
2021, my lord.
Has your representation been rejected?
Yes, my lord.
Oh, fantastic.
Rejected, my lord. It is not permissible under this existing rule, my lord.
Very well. In
If rule
pursuant to
was
the
where-
comment
if the-
memorandum and the yeah, so and so manual, so and so, so and so, so and so, yeah, we have an enhanced freedom. Where is your representation?
My lord, representation is space 34, my lord.
So, very well.
Now, presently, my lord, he is going only 9,000 salary, my lord. At least they may take some, my lord, action for enhancement also, my lord. 9,000 rupees, my lord, 2,000.
Mr. Hawk, you sometimes forget that I am sitting in a judicial court.
My lord.
Eh? You sometimes forget. I am sitting in a judicial court, not what is to be done
Yes,
or
yes,
what
yes.
is not to be done. You make those things, please, before the Chief Justice in his administrative side. Then he will listen. But not me. I don't have the power to do that.
Yes, sir.
There are two notifications which are holding the field. So your regularization, if you're asking for that, your representation is for what? Of so and so, so and so, so and so in respect
Absorption,
of
my lord.
absorption in the vacant post of so and so under the establishment of the honorable so and so for consideration of the higher year and relaxation of the age. And how many years you have been working?
Yes, my lord. I am working under the same establishment, my lord, at the FTC North Salmara of Haipuri, my lord.
2015,
My lord.
and you are still working.
My lord, he's still
Yes.
working, my lord. He's still working, my lord. It's more than 11 years of continuous service, my lord.
Huh?
More than 11 years of continuous service, my lord.
Your framing of the writ petition is not proper. What you are asking in number 3 is the effect of challenging the Guwahati High Court Service Appointment Conditions and Service Conduct Rules 1967. But this is not, it is not done under 6D.
My lord, 6D, my lord,
Mr. Counsel, you are not understanding that. See my judgment.
my lord.
You have not seen it properly. You see, first is this is a power, page 31. This is the first notification by which the power is exercised under 229. Okay.
My lord.
Okay. Now kindly see the next. Here it says next notification of 4th of January.
Yes,
Pending framing of the rules of so and so, so and so, so and so shall be governed by the rules framed and applicable so and pending and for such framing and so
Yes, sir.
all process for recruitment of so and so. Now see, and its outline and notified notification dated and pending for such framing and approval of all processes for undertaken in a when no appointment has been issued till date stands halted or cancelled. So therefore, by this notification, it was applied to the district judiciary.
Yes, ma'am.
So you need to challenge this notification.
21, my lord.
Yes. Without challenging this notification, how is it possible? So this 2016 notification was applied to the district judiciary by the 2021.
Yes, yes, my lord.
So
Earlier it was only
therefore,
undertaking.
you need to challenge this notification.
My lord.
Unless you don't challenge this notification, you cannot get out.
Yes,
That
ma'am.
is the only way out.
Now I can.
And I'm not here to give you advice how to do so.
My lord.
Isn't it?
Yes, ma'am.
You know how to do it. What is the ground to be taken?
My lord.
What is your ground? Tell me.
Now I'll take. My lord.
What? What ground?
And one case for regulation, my lord, I will my lord, refer to my lord, Uma Devi case also, my lord.
What?
Uma Devi, my lord, Uma Devi, my lord,
Umadevi, forget about Umadevi. Go by Dharam Singh.
Dharam Singh.
Okay?
Yes, sir.
That is another aspect. But you, how are you going to challenge it? Well, on what ground?
Because,
This notification, how are you going to challenge it?
my lord, here, my lord, this case, my lord, earlier this notification was only for the High Court and applying branches, my lord. Now this notification, my lord, and there is, the rule has not yet been framed, my lord.
Mister, you need to read some provisions of the Constitution. Article 235,
My lord,
read it.
my lord,
There are few judgments.
my lord.
229 is the power of the Chief Justice.
Yes,
Power of, when it comes to subordinate judiciary, it is the power is to be given by the High Court.
yes.
High Court means the full court. Full court means 235. Now apply your mind. I don't need to now form.
Now, my lord,
Yeah.
now I,
Draw.
I'll get, yes, my lord.
Mr. S. Hawk, the learning counsel submits, appearing on behalf of the petitioner, submits that there are formal defects in the instant petition. And as such, the petitioner would like to withdraw the instant petition without prejudice and would further like to, and without prejudice and liberty, without prejudice. The learned counsel further submits that liberty may also be granted to the petitioner to again approach this court. Taking into account the said submission, the petition stands closed on withdrawal.
My lord.
Stop. The withdrawal of the instant petition shall not prejudice the petitioner. And further, the petitioner would be at liberty to approach this court.
My lord. I am deeply.
বাকি নামবোৰ ভৰাই দিব।
May I please, your lordship?
Yes, what is this?
Lord, the matter pertains to, my lord, reimbursement of outstanding medical expenditure of the
What?
petitioner. Reimbursement of outstanding medical expenditure, my lord.
By whom? Who has not paid?
By the, my lord, ESI. Employee State Insurance, my lord.
Issue notice making it returnable on 23rd of September 2026. You are paying for whom?
Respondent number 2 and respondent number 3, Lordship, on behalf of Mr. Rem Smith.
And what are 4 and 5? Same?
For that, I have no instruction,
Both are
Lordship.
failed.
I have no instruction pertaining to that, Lordship.
Yes, I, all are ESI,
Then all are 4 and 5.
all the respondent.
We are paying for everybody.
Same,
No, this,
under the ESI.
this won't be there. 5 won't come
Yes,
in.
yes, ma'am.
4 will come in. 2, 3, 4. So and so appears on behalf of the respondent number 2, 3, and 4. No central government council. Hey, there. Mr. K. Gogoi appears on behalf of the respondent number 1. Stop. Extra copies be served upon the learned counsel representing the respondent numbers 1 to 4 by tomorrow. Insofar as the respondent number 5 is concerned, the petitioner is directed to take steps by way of speed post by tomorrow. The case of the petitioner herein is that the petitioner is entitled to. You are enrolled, no?
Yes, my lord.
The petitioner
I
is
have a policy.
an insured. The case of the petitioner herein is that the petitioner is an insured person
Yes.
attached to the ESI scheme dispensary Kalapahar.
Yes.
Full stop. The petitioner had submitted bills to the tune of rupees 6,03,924. However, the petitioner had, on account of his medical ailment, yours,
Yes,
petitioners or anybody else,
my wife, my lord.
on account of his wife's medical ailment, had incurred an expenditure of rupees 6,03,924. Thereupon, the petitioner submitted the claim for reimbursement of the said amount. And the said amount having not been paid, the petitioner has approached this court. The respondent number 2, 3, and 4 are directed to place their affidavits as to why the petitioner would not be entitled to the reimbursement as claimed.
Lord, pendency shall not bar to making the.
Pendency of the writ petition shall not be a bar upon the respondent authorities to consider and make payment to the petitioner if so permissible under law.
Oblige me.
What is this?
Lordship, the respondent number 4 invited tender for solid waste management plan,
Who is respondent number 4?
Makum Municipal Board, Lordship.
Then,
Lordship, Lordship may kindly come to page number 31. Name of the work, construction of proposed solid waste management plant at Makum, ULB of Assam under SBM on engineering.
now tell me, why are you here?
Lordship, the prescribed eligibility criteria is at page 35. Lordship, may kindly come.
Page 30?
5.
Yes.
2 criteria, work experience. The bidder should be class 1 PWD contractor. Experience of having successfully completed 2 similar work in Assam during the last 3 year ending previous day of the last day of submission of tender. And the eligibility criteria B is the bidder should have had minimum average annual financial turnover of 7.7 crore 50 lakh on construction work during the last 3 consecutive years ending March 25. And this has to be certified by a chartered.
What was the date of the tender?
Date of the tender is 7th February 2026.
26.
Lordship.
7/4/7/2/2026.
Lordship.
Then,
Lordship and
but here it says that he should have last 3 years ending March 2025.
Lordship.
Meaning thereby from
That-
2024.
That is written down below. 2022-23, 23-24, and
Ah.
24-25.
So you need to give the CS certificate.
Lordship,
Be uploaded.
kindly come to page 303.
306.
303, Lordship.
3.
3, not 3. 303.
Okay. Yes.
Lordship, the private respondent number 5. This is the turnover certificate duly certified by CA. The cumulative of the entire area do not come to 7 crore 50 lakh, Lordship.
Wait. Now first you satisfy yourself.
Lordship.
Here.
Lordship,
You
330.
qualify. First, let
339.
us see the technical bid. Opening of the technical bid.
Lordship, that Lordship, after the bid were submitted, by later annexure 3, we were called upon
Page.
page 270, Lordship.
Now my question is, has the technical bid been opened?
Lordship,
Where is the technical bid minutes?
that is at page 300, Lordship.
Yes. As per the decision of the tender evaluating committee and agreed by both the bidders, 7 working dates, that is on or from so and so, were allotted to both bidders for submit of the shortfall documents. Both the bidders submitted the response here. The documents submitted were presented before the event. As per the evaluation criteria, both parties, namely Call and Fix and Bidur, are qualified for financial evaluation. Then,
Lordship, immediately thereafter, page 301.
who is L1?
L1 is the private respondent number 5.
Then,
Lordship, financial bid were open and he was declared L1.
then,
Lordship, my case is that he do not the prescribed eligibility criteria.
what are
They
the
are-
documents which were submitted?
Yes, the document that was submitted
Hmm.
in e-portal is at page 303.
300?
3, filed by respondent number 5. The first eligibility criteria, they do not meet.
303. When was this submitted?
This was submitted along with their bid, Lordship.
So 2022, 23, 24. So he does not have 7.5.
Cumulative, we are not talking about average. Even cumulative do not qualify him for 7 crore 50 lakh.
Following annual turnover for the outset. Then,
And my document is at page
wait,
339.
there might be something else. Otherwise, they don't make so much of mistake. Something is wrong somewhere. Where is again the criteria? Page
Page 35, Lordship.
shall have minimum average annual financial gross of rupees on construction works during the last 3 years. So notice letter of acceptance issued.
Not yet, Lordship. We have already made a representation that since few document pursuant to meeting dated 10/6 has not been provided to us, so LOI should not be issued and the
Where
document,
is your representation?
Lordship, annexure 375, Lordship.
So you are not sure from your representation.
Lordship,
That is this document.
Lordship, there are two aspects. The eligibility qualification is at page 35, which says that they should have completed two similar type of work and financial eligibility required. Those are already, they cannot develop by filing subsequent document. Lordship, by minutes dated 10/6, both the bidder were called upon to furnish additional document. What document they have furnished, we don't know. But the CS certificate could not be developed. That is for the previous year, Lordship. So my case is that they cannot be qualified even if they have deposited the deficit forms, affidavit, the integrity agreement, which were not in the initial bid. Those certificates they might have deposited, which are not in our process. We have requested them to either provide us or upload it. But my case is that the CS certificate, which shows that they do not qualify the financial bid, that cannot be developed by way of additional document.
Issue notice making it returnable on 26th of August 2026. Housing, who appears? Mr. So-and-so appears on behalf of the respondent number 1 and 2. Swas Bharat? Swas Bharat, anybody? You are not there, Mr. Gogoi? Represented by the State Mission Director, Swachh Bharat Mission, Urban Public Health Department. So the when so appears for the respondent number 3. Executive Officer, Makum Municipal Board, you. Executive Officer, government appears. No. Board, it is a different thing. But when it comes to the executive officer, is an appointee of the state. Because then it will be fast because I am going to pass a stay order. So and so appears for respondent number 4. Extra copies of the writ petition be furnished during the course of the day. As regards the respondent number 5, the petitioner shall take steps during the course of the day by speed post. In addition to that, the petitioner is also directed to effect service upon the respondent number 5 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner is the proprietorship firm of one Sri Uday Prakash Kanoi, a request for proposal for establishment, construction, supply and procurement, fabrication, erection of machineries, trial run, and commissioning of material recovery facility (MRF) and waste to compost W2C plant in Makum as per SWM rules 2016 under SBM (U) on engineering, procurement and construction (EPC mode -1 basis was issued on 7/2/2026. The petitioner, along with the respondent number 5, had participated in the said bid. In the minutes of the meeting held on 21/6/2026, both the petitioner as well as the respondent number 5 was held to be technically qualified. And thereupon, the financial bid was opened on
14/7 Lordship.
on
14/7
14/7,
Lordship.
2026, whereby the respondent number 5 was found to be the lowest bidder. Full stop. It is further relevant to mention that the petitioner on 22/7/2026 submitted a representation to the Deputy Commissioner Tinsukia District for providing certain documents.
To the executive officer, and a copy was given to DC also. Lordship.
To the executive officer as well as to the Deputy Commissioner Tinsukia District, to the respondent number
4 and 2.
Huh?
Deputy Commissioner, respondent number 2,
and
and respondent number 4, executive officer.
as well as the respondent number 4. Wherein it is mentioned that the petitioner, that the respondent number 5, wherein it is stated that the documents which were subsequently submitted by both the petitioner as well as the respondent number 5 were not uploaded. And as such, requested their documents be furnished to the petitioner. It is the further case of the petitioner that the said documents were not furnished, but there is a move to grant the contract to the respondent number 5. And under such circumstances, the petitioner has approached this court by filing the present writ petition on 5th of August 2026. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that the request for proposal contained various parts. Section 1, Part A of the request to the proposal refers to general information. Referring to the information and the instruction for the contractors for e-bidding, the learned counsel submits that for the purpose of being eligible, various criteria have been stipulated therein. One of the criteria being clause 1, capital B, bracket 1, small 1, Roman 1, is that the bidder should have minimum average annual financial turnover gross of rupees 7 crore 50 lakhs on construction work during the last 3 consecutive years ending March 2025, balance sheet should be duly audited by the charter accountant. The learned counsel further submitted that in the said clause itself it is mentioned that the CS certificate has to be uploaded for the last 3 financial years, 2022-23, 2023-24, and 2024-25. In this regard, it is very relevant to take note of the learned counsel for the petitioner further drew the attention of this court to the certificate which was submitted by the respondent number 5, issued by the charter accountant, dated 6th of December 2025, wherein the turnover of the respondent number 5 for the years 2022-23, 2023-24, and 2024 and 25 were rupees 1 crore 57 lakhs 15,855, comma, rupees 1 crore 4 lakhs 87,855, and rupees 2 crores 6 lakhs 34,234.93 respectively. The Learned Council submitted that cumulatively also the respondent number 5 does not meet the criteria as stipulated in clause 1, capital B, small Roman 1 of the instruction to the bidders. And as such, the respondent number 5 could not, under no circumstances, could have been technically qualified. Where is your document?
339, Lordship.
339.
These are in lakhs, Lordship.
This is for whose?
Petitioner, call and fix.
How do we know?
Lordship, signature of bidder down.
What?
There is a signature of bidder, call and fix.
No, I'm not there. Does the certificate mention your name?
Lordship, the certificate in the left-hand side column, the signature of the bidder is there, and the right-hand.
I'm not on that. Does the certificate mention your name?
Lordship, the certificate do not mention, but my case.
No, so you, that
the
means you have
certificate-
not submitted the certificate.
Lordship, may I submit?
No, don't
Lordship,
submit.
this
No,
certificate
that is why it therefore seems that on 21/6 this has happened. Why did you wake up so late?
14
After opening of the
No,
L1.
no, Lordship, I have given a statement that it was uploaded, minutes were uploaded on 14/7. I have given a statement, Lordship. Lordship, my case is that the certificate in the left-hand side, my signature, this is not for
I'm
the.
not concerned. The certificate has to say that it is your document.
Lordship, this is supported by balance sheets. The figures are reflected therein, Lordship. These are supported by balance sheet, Lordship.
Where?
Lordship, I will take your Lordship. Lordship, may kindly come to page 350 for a 350.
How do I know that you submitted the document?
Lordship, these are downloaded from the website, e-portal website, Lordship.
Huh?
From the tender portal.
You're downloading it, it will be showing it somewhere.
Lordship, we have made downloaded documents have been filed. Page 350, gross receipts. This corroborate with my certificate, Lordship. For a particular year, others are also, balance sheets are also there. 350, above, right hand side, by gross receipt. 527, this is corroborating with 22-23.
From construction works,
Left
not gross receipts. From construction works. Where is your construction work receipt?
These are my gross turnover.
Gross turnover won't do. On construction work.
Lordship, I have given the completion certificate also.
No.
I have given the
construction
completion
work.
certificate also. That is at
That is fine. Anyways. Answer. The Learned Council therefore submits that the proposed award of the contract in favor of the respondent number 5 requires to be interfered with in as much as the respondent number 5 is not technically competent. This court have given an anxious consideration to the respective submissions. No, full stop. The Learned Council for the petitioner further submitted that there is a proposal, there is a move for issuance of the letter of intent to the respondent number 5.
Lordship.
And as such, this court may pass certain interim directions. This court had given an anxious consideration to the respective submissions and have also perused the materials on record. Full stop. From the materials on record as has been placed by the learned counsel appearing on behalf of the party petitioner, this court prima facie appears to this court that the respondent number 5 did not comply with the requirement in terms with clause 1b Roman 1 of the instruction to the bidders as regards its technical competence. This court have also perused the materials on record for the petitioner and the financial information which have been submitted as Annexure 7 series at page 339 do not contain the name of the petitioner. The learned counsel appearing on behalf of the petitioner further submitted that though their name is not mentioned in the financials in the certificate issued by the chartered accountant, but there is the signature of the petitioner, and further referred to the balance sheets which were submitted by the petitioner. It is relevant to take note of that from a perusal of the technical bid evaluation, which was done on 21/6/2026, it is apparent that there has been certain waivers in as much as various documents were not placed, and later on both the petitioner and the respondent number 5 have been permitted to submit certain documents. The question as to whether there was any waiver of these terms and conditions is, however, not known. This court also takes note of that in the representations which were submitted by the petitioner on 22/7/2026 to the respondent number 2 and respondent number 4, there is no specific mention that the respondent number 5 did not have the eligibility criteria, did not qualify in terms with clause 1b Roman 1.
We have stated, we have
Where-
reasons.
Where
Lordship,
have you
last
mentioned?
paragraph, we have reasons to believe that the documents submitted by Vidur may not be comply with the tender requirements.
So didn't I say specific mention?
So this
See,
is the
what
language
order did I mention? There is no specific mention
I would.
to so and so. Taking into account the above, this court is of the opinion that there is a prima facie case made out by the petitioner. Insofar as the non-compliance to clause 1b1 of the instruction to the contractors. This court also takes note of that the respondents herein. It is the statement made by the petitioner that till date, there has been no issuance of the letter of acceptance in favor of the respondent number 5 or any contract have been entered into. Considering the above, that as this court is presently issuing notice in the present proceedings, it is the opinion of this court that certain interim directions are required to be passed, else the filing of the instant writ petition, filing of the instant writ petition would become infructuous. Accordingly, this court passes the following interim directions. Number 1. In the circumstance that till date, that is today, till date, letter of acceptance have been issued in favor of the respondent number 5 and or any contract agreement had not been entered into. The respondent authorities, more particularly the respondent number 4, is directed not to issue the letter of acceptance and or enter into any fresh agreement, any contract with the respondent number 5 till the next date. Number 2. In the circumstance, the letter of acceptance and or the contract agreement has been entered into with the respondent number 4, with the respondent number 5, it is observed that the said letter of acceptance and or the contract agreement, if entered into, shall be subject to the outcome of the writ petition.
The copy they have served it from page 336 onwards. This is the condition. We are not able to read anything. Copy they have served from 336 onwards. This is the condition. Not a single word we can read.
We'll serve a fresh copy. Much.
Affidavits filed.
Complete, your lordships. Lordships, I have received instructions. Lordships had directed to file an affidavit regarding the rehabilitation system, if there is any, your lordship. I have received the instructions today, your lordship.
You're paying for flood and river erosion management agency, there is something
Government advocate, Your Lordship.
you are paying. Mr. Counsel, have you filed any application for settlement?
No, Your Lord.
After eviction, we immediately approached the Deputy Commissioner office for providing us rehabilitation and resettlement.
That is another thing, but settlement?
Settlement, prior to our evictions, in these areas, Tozi Khazanas were taken and our Bosundara application were filed and
Counsel, you need to file those applications.
yes.
Then only this court can do something to that.
Right.
Then only you can get in there. As of now, you are still staying in the periodic patta land of
Yes, sir.
somebody. But it cannot be a permanent
No,
solution to that. So a permanent solution can only happen by two ways. Either you need to submit applications for allotment. Then only this court can give a push to that.
Yes, sir.
That's the only way out. You file your affidavit in
Yes,
the
Your
meantime, you bring your stand because that is
Yes,
an
Your-
important stand needs to be brought in.
Yes, Your Lordship.
Whereby you don't have a rehabilitation as regards eviction.
Yes, Your
land.
Lordship.
But then also there is a question as to how do you take care of the citizens of India, of
Sure.
your state? After all, the state is a welfare state, so
Sure.
something needs to be worked out somehow. It is for the executive to do so.
Lordship, as per my telephonic instructions, if they are flood and erosion hit victims, they may produce the documents, Your Lordship, if they have any. Accordingly, that application.
Flood erosion victims.
Yes, they need to show that they were residing in that area and they
Then
are
in the
hit
meantime, submit
thereafter.
your applications. We'll have a, we'll sit with, you submit your application. In the meantime, has all the respondents filed their affidavits?
The government has, DC has filed. Your Lordship.
No, that is one. What about Mr. D. Gogoi, PhD?
PhD ballot, don't have file ballot, but we are providing everything in Gwalpara. And there are a lot of petition ballots, wherever they go, the schemes are already in place. And that part that
Put it on affidavit.
now latest instruction is that the land they are residing is a patta land. So now the approval won't be granted for a scheme to be erected in a public land.
Private land.
This cause difficulty.
You bring it on
I'll bring it.
record, then I'll pass an order to the effect that you shall do it. Irrespective of what it is, you do it. You see, these are temporary schemes. One has to take note of. That is what I'm telling the learned counsel for the petitioner. This is a temporary measure. One has to, after some time, you need to move on somewhere. Either you cannot remain in somebody's land for some time because tomorrow that person will also say, whatever they provide will be only for the purpose of a temporary measure. So you need to move somewhere to get something somewhere. So that is why you need to file your application for allotment, one thing. And secondly, for maintenance of whatever the health you are maintaining it. Let us file that. PhD, you file your affidavit, bring it on record, that thing. And what is the difficulties faced by you, bring it on record. So all the,
Seven lordship, we already been file our affidavit.
Also, Your Lordship, in few cases, extra copies are not served yet. In few cases, extra copies are not served yet, Your Lordship. I had to request them to serve me extra copies. After that, I send my letter, Your Lordship. It's being really difficult, Your Lordship.
We've served your
After
lordship.
issuance,
We'll
yes, in some
serve it,
case,
no issue.
requesting many times, Your Lordship.
In fact,
कोई
the
नहीं,
I-
sir.
there are eight
Let us
cases
expose
which
them.
I
कोई
had-
नहीं. Yes, Your Lordship, copies are not served.
Served to the government advocate, আপোনালোকে নাপায়।
This court duly takes note of that the service upon all the respondents are complete. Ms. N. Bodloy, the learned counsel appearing on behalf of the Revenue and Disaster Management Department, submits that though notice have been issued, extra copies in some of the petitions have not been provided. The learned counsel for the petitioner shall do the needful. In addition to that, Ms. N. Bodloy has placed before this court an instruction issued by the Additional Secretary to the Government of Assam, Revenue and Disaster Management Department, wherein it is mentioned that the Revenue and Disaster Management Department do not have any rehabilitation scheme for those who have been evicted from government lands, wetland, reserved land, tribal belt, block and forest land, etc. An affidavit in that regard be filed by the Revenue and Disaster Management Department. So that this court can further be filed by the respondent by the Revenue and Disaster Management Department. It is also the opinion, this court have also inquired with Mr. D. Gogoi as to whether the petitioners herein have been provided the necessary basic amenities. The learned counsel submitted that certain amenities have been provided, but certain schemes cannot be applied in the present case in respect to the petitioners of the present batch of writ petitions, inasmuch as they are residing in private lands. It is the opinion of this court that the PHE department also needs to bring on record their stand by filing the affidavit. And more particularly taking note of, by giving due consideration to the observations made by this court at paragraph number 3 of the order dated 13/3/2026. This court, during the course of the hearing, inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioners, pursuant to their eviction, have made any application for settlement. The learned counsel appearing on behalf of the petitioner submitted that at the time when they were residing in the government lands, from where they have been evicted, the petitioners have submitted applications for settlement.
Lordship, he said representations.
Taking into account that the petitioners are flood and erosion affected victims. It is the opinion of this court that the petitioner would be well advised to submit applications for settlement. within the contours of so that the respondents' authorities can consider the same within the contours of the Assam Land Policy 2019. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petitioners would submit fresh applications. This court also takes note of the submission of Ms. N. Bodloy, the learned counsel appearing on behalf of the Revenue and Disaster Management Department, who submits that if the petitioners submit applications claiming themselves to be river and erosion affected victims, due consideration can be made in terms with the Assam Land Policy of 2019.
If they provide the validating documents, Your Lordship.
The petitioner, taking into account the said submission, the petitioner, the learned counsel for the petitioner submits that the said applications will be submitted with due supporting documents. Accordingly, list this matter again on 25th of September 2026 for an update. In the meantime, the respondents who have been asked to file their pleadings, affidavits, shall file their affidavits on or before 22nd of September 2026. The interim order which have been passed in the present proceedings shall continue till the next date.
Obliged.
I'm so deeply obliged, Your Lordship.
Affidavit filed.
What's the affidavit filed?
You just tell.
Lordship, page 14, paragraph 3.
Let me first see what is the direction.
Direction.
Release the admitted dues to the petitioner within a period of 4 months from today. What is your stand?
Lordship, steps are being taken to pay the Lordship, the admitted dues, Lordship.
When?
Lordship is,
That order was passed 6 years back.
Lordship.
And who is going to pay the interest?
Lordship, on their respect, Lordship, the paragraph 6 of my affidavit says, Lordship, they could not establish, Lordship, defect from anyone, Lordship, they says, Lordship, that the responsibility has not yet been determined against any individual official, Lordship. Paragraph 6, page 15, Lordship, that says, Lordship.
Paragraph?
6, Lordship. Page 15, Lordship. Otherwise, to see the principal amount processed, Lordship, in his present budget, Lordship.
So we asked you have an additional chief secretary or secretary?
Secretary is there, Lordship.
He's the boss of all, so let him pay from his pocket the interest. Let him pay.
Lordship,
He is responsible.
Lordship, this affidavit has been filed by the chief engineer, Lordship, and secretary is not a party here, Lordship.
Not necessary.
Lordship.
No, if you have difficulties in assigning
Lordship.
who is the person concerned, so therefore it is really.
Lordship, I'll take instruction from the secretary also in this regard in that case, Lordship, because secretary is not a party.
Mr. Upadhyay,
Lordship.
if you pay the amount, this court can consider it. If it is me,
Lordship.
I will take care of that. But if you don't pay the amount or you
No,
are saying about this thing, when are you paying it?
We are paying, Lordship. In fact, Lordship, paragraph 3, Lordship says, Lordship, the demand has already placed before
I'm not
the.
on that. I'm not on that. My
Lordship.
question is when you are paying. Whatever moves you do, that's a different thing. When you are paying it, then can pass an order taking into account something to that effect, which I have in my mind,
Lordship.
but not by way. You
Lordship.
don't pay and then you say about interest to be waived, nothing works in this
We are-
court.
We will pay, Lordship. Lordship,
Next week,
not next week.
next week.
Lordship, we fix the matter, Lordship, in the
It
month.
was around 27th of July, so
Lordship.
therefore, when are you paying?
Lordship, we fix the matter in next month, Lordship, 15th September or like
No,
that,
too
Lordship.
late.
In the meantime, Lordship.
I won't be here then. Other courts will put the claim on you. There's a direction of payment of interest. Payment of interest is 6% on 57 lakhs. It's a huge amount.
Lordship, yeah. That is always there, Lord.
So therefore, if you pay it, this month I'm sitting in this bench, I can help you out.
And Lordship, my pain is perhaps not press on the interest part, Lordship.
We will take care of that.
Lordship, Lordship.
Take care of your submission.
Lordship, I'll
Tell
inform.
them, if you pay
Lord-
it, then we can. go.
Lordship, Lordship, I am obliged, Lordship, I am obliged, Lordship.
This court have duly taken note of the affidavit which has been filed by the chief engineer, irrigation department, wherein it is mentioned that the demand for fund against the order have been placed on 10/5/2026. This court also takes note of that the directions were passed by the learned coordinate bench in the order dated by an order dated 6/10/2026. And almost 6 years have passed by. There is also a direction for payment of interest with effect from 8/10/2018 till the final payment is released. The delay in making the payment would affect the public exchequer. And as such, this court is of the opinion that if there is further delay in making payment of the principal amount, the officials presently holding the officers should be held responsible. Mr. N. Upadhyay, the counsel appearing on behalf of the respondent, submits that effective steps will be taken to list this matter on 28th of August 2026 for an update.
2/8, Lordship.
Pay that amount, I'll take care of it.
Lordship. Obliged, Lord.
IA, what is this IA business?
IA is item number 17, my lord, for filing for passing of interim order. But
What?
then that was not considered.
Processing and issuing the license in favor of the petitioner is operating the date. Okay, what is the case about? Why there are two different persons?
One item number 16, my lord, I have approached regarding for withdrawal of the NOC. And item number 17, they have filed an objection in issuance of the approval in my name. Page-
Item number 16 is
Page number 20.
Rohini Kumar Neo.
My lord, page number 29, NOC was given in my favor by the Gau Panchayat.
For what?
Opening of IMFL on license, my lord.
Page number?
29, Annexure 2.
The Rohini Kumar Neo so and so.
That was in 2020, my lord.
Okay, now what has happened?
Page number 32, my lord. It is the impugned, my lord. In 2022, my lord, that NOC was withdrawn. This was issued by the Gau Panchayat directly to the
Then?
commissioner. Now,
What is this court going to do?
now because of this withdrawal, my lord, they have not, now, my lord, this withdrawal, my lord, I have not been issued anything regarding this.
Not necessary.
Well.
Did you get that certificate? When you were issued that certificate earlier,
My lord.
was the public involved? Was the public put to notice?
Rule came later on, your lordship, that public notice we should pay some for 15 days. That is a subsequent rule after application of his. He applied for it. There and writ petition number.
But as of now, you have not issued a notice.
issued a
So
license.
now the rule has come into the picture. So once the rule comes into the picture, you have to have the,
According to this.
that is 295 or something.
Yes, yes,
Yeah.
lordship. Mm.
So therefore, there is no quarrel with that proposition. Now he says that without notice, this Gaon Panchayat have done it.
Yes, my lord.
What case is this? What is your right?
No,
To trade in liquor?
No,
No fundamental right?
that's extra commercial.
Then
no, only thing is that the
you manage the secretary of this Gaon Panchayat to get this earlier certificate. And now you are later on that this managing affair did not work. The public have objected, so this is the problem. So to give you a notice,
my lord,
they should give you a notice of hearing.
my lord, the only
You
thing,
want a hearing?
what is the,
No, my question is, do you want a hearing?
my lord,
Okay, we give you a hearing. We don't set aside this. We say that, okay, you want a hearing, you submit a representation to the Borsala Gaon Panchayat, they will consider to consider
no, only thing is that
to
what is the,
consider as to whether the withdrawal of the NOC should be done or not, whether there is a public objection or not. These things will be considered by giving the other people who have submitted complaints, let them there. Matter over.
and what is the objection and what not, my lord, I have not been received anything, my lord, that is the only one.
Not necessary.
No, my lord, only,
You don't, this is not a those type of matter. Those type of matter is no, this is not a matter to that extent. You get a no objection from this particular thing. And what is that no objections? Let us see, read it. Read the no objection. The most fundamental word in the no objection, there is a spelling mistake. Isn't it?
To whom it may concern.
No. See, main thing. See, Rohini Kumar Nayak, DCDs, not deserves. Isn't it?
Even at the top, your lordship, to whom.
That too is there. That we can just not there. But the very no objection is there's a problem.
D series.
unfortunately, the Gaon Panchayat has misplaced everything that is on record.
Huh?
The Gaon Panchayat has misplaced our entire record. They don't have the records that is on record, that flag mark B. Against that, they
The
have,
only thing is, we can do one thing. Ask you to again apply, and they shall consider your application for no objection by duly taking note of the public objections. That's it. That's the only order I can pass. And what is the other case?
that
Other
is
case gets allowed with this order?
indirectly.
Next to this file, they have the respondent in the other case, your lordship. They are the respondent in the other case.
Who has filed the other case?
It's on Keshav Goko. He says we had resident, the complainants.
Okay. Heard Mr. H.K. Sharma, the learned counsel appearing on behalf of the petitioner in WPC number 4845/2022. Full stop. None appears on behalf of the petitioner in WPC number 1130/2021. Full stop. Mr. S. Datta appears on behalf of the Panchayat PNRD. And Mr. Soy R.R. Gogoi appears on behalf of the Excise Department.
Number
Both the writ petitions are taken up for disposal by this common order. A no objection certificate was issued by the Borsila Gaon Panchayat, Borsillah, Gaon Panchayat, in favor of the writ petitioner in WPC number 4845/2022 to the effect that the said Gaon Panchayat did not have any objection to open Assam an IMFL on shop at Bandorijan Grant in the rented house of Siba Kosari, located at Chokai Paduli, Gao, PO Madhavnagar, PS Aluating, Moza Dupdar, under Borsila Gaon Panchayat. On account of issuance of this no objection, a writ petition was filed by the petitioners in WPC number 1130/2021, who are residents within the Borsila Gaon Panchayat, objecting to the no objection issued by the Borsila Gaon Panchayat. Pursuant to the filing of the said writ petition, the Borsila Gaon Panchayat, by the communication dated 27/4/2022, issued to the Commissioner Sibsagar District, Upayukta will be Commissioner. Upayukta will be Commissioner or Deputy Commissioner? Deputy Commissioner, that is why you have made that mistake also. To the District Commissioner, Sibsagar District, informing that the Borsila Gaon Panchayat has withdrawn the NOC dated 20/10/2021, issued in favor of the writ petitioner in WPC number 4845/2022 on the ground of public complaint, on the ground of objections raised by the public. It is under such circumstances the petitioner in WPC number so and so 4845 have approached this court by filing the writ petition challenging the communication dated 27/4/2022 issued by the Borsila Gaon Panchayat on the ground that the said withdrawal of the no objection certificate was issued by the Borsila Gaon Panchayat without giving the petitioner an opportunity of hearing.
Secondly, without serving 27/4, I obtained it by RTI, madam, page
Without?
31. At page 31, I applied for the RTI, only then I could get.
That is different, but first it has been,
Yes.
Main reason is this. Mr. H.K. Sharma, the learned counsel, appearing on behalf of the writ petitioner in WPC number 4845/2022, further submits that even the copy of the impugned order dated 27/4/2022 issued by the Gaon Panchayat was not provided to the petitioner, which the petitioner could obtain under the Right to Information Act 2005. This court have duly perused the materials and record as well as heard the learned counsels appearing on behalf of the parties. The writ petition being WPC number 1130/2021 being a writ petition filed challenging the NOC which was granted to the writ petitioner in WPC number 4845/2022 had become infructuous in view of the fact that the NOC which was granted to the writ petitioner in WPC number 4845/2022 was withdrawn by the impugned communication dated 27/4/2022. In the backdrop of the above, let this court consider as to whether the action on the part of the respondent action on the part of the Borsila Gaon Panchayat to withdraw the NOC so granted to the petitioner in WPC number 4845 is sustainable in law, is required to be interfered with. This court duly takes note of this is rule 295,
This shifting, Your Lordship.
not shifting, that the public objection.
Public objection is rule 295. Yes. 295.
Duly takes note of rule 295 of the Assam Excise Rules 2016, isn't it?
Yes.
Which stipulates that the license can be granted if there is no objection within. There is no objection of the public residing within the radius of 75 meters from the location. The question as to whether this court further takes note of that the said rule came into effect with effect from 1/1/2019. Under such circumstances, there is a requirement for the Gaon Panchayat to carry out an exercise prior to issuance of the no objection certificate. This court also takes note of that there is no fundamental right of a person, of a fundamental right to carry on the business of liquor. And as such, the grant of a license for an IMFL onshore is subject to the provisions of the Assam Excise Act 2000 as well as the rules framed therein under. This court is not inclined to interfere with the no objection, the withdrawal of the no objection certificate by the Borsala Gaon Panchayat dated 27/4/2022. However, taking into account Rule 295 of the Assam Excise Rules 2016, However, it is also observed that when there is a no objection required to be taken, when no objection is applied to for, it is expected that the Gram Panchayat in question shall duly consider such application within the parameters of law. Accordingly, both the writ petition stands disposed of with the following observations and directions. Number one, WPC number so-and-so 1130/2021 is closed as it had become infructuous. Number two, this court is not inclined to interfere with the withdrawal of the NOC dated so-and-so 2020 to date to go so, by the communication dated 27/4/2022. However, this court observes that in the circumstance the petitioner submits a fresh application to the Borsila Gram Panchayat, the said Gram Panchayat shall duly consider the said application for issuance of the NOC by taking into consideration the opinion of those people residing within the radius of 75 meters of the proposed site for setting up the IMFL on license shop. License. Interim order stands vacant. What interim order? How can there be an interim order? Interim order stay.
That was suspended, madam. Impugn order was suspended.
Still you can get the license.
And I have just checked in the map, my Google map. It's exactly in the flood affected area. This place, man.
So they need their own shop there.
Much.
May I please your lordship? My lord, in this case, I was the highest bidder. It pertains to settlement of a sand mahal. My lord, impugn order is at page 33, Annexure C, whereby we were aggrieved.
Where?
At page 33 of the writ petition. If your lordship refers to the Annexure B at page 32, this is the tabulation. As per this table, the writ petitioner was considered as the highest successful bidder who offered a tender amount of 17,10,000.
This writ petition has become infructuous.
Well, no such condition is there because
3 years for 3 years.
3 years, fine. But
2 years.
what happens?
For a period of 2 years.
No, but in the advertisement,
So and so.
lordship can allow just.
We know, we set aside this. We set aside this, but the fact is you don't get anything out there. You have to go for a fresh one.
Normally what happens in a public tender, my lord, the offered rate always remains, they carries a validity period. In the instant case, no such, condition was there in the tender condition itself. So had there been a condition that the offered rate will remain valid for 230 days, 290 days, then the matter would have been different. The matter would have become infructuous. In the instant case, illegality was committed in the year 2023. We immediately approached this honorable court by way of filing the writ petition.
Then why didn't you ask the court to immediately finish it off? Why were you sleeping all this while? The matter came in 2023 and has come today in 2026.
It was listed in between, and
Where? There is only
and
one
there was
order.
one in,
There's only one order. It was listed before the Lozima court, it's a different thing.
yes, yes.
That court has
But
no
the-
business.
One effective order was passed by this honorable court whereby this illegal
Illegal,
that,
very
that
well.
was kept in
illegal.
abeyance.
Anyway, so what is there now, Mr. Gogoi,
So-
you need to now have a fresh tender. We need to have a fresh tender.
Otherwise,
You can't go with this. We set aside this because you are giving it to the second lowest. Now you have to go for a fresh tender because the period was only for 3 years. Now the 3 years have already elapsed.
Elapsed.
So once the 3 years have elapsed, now the rate must have gone up. And
Condition of validity was not there. That is what I have just made a submission before your lordship. That is up to your lordship.
Mr. Counsel, kindly see the
Yes, yes,
tender notice.
yes, it is.
Statement showing the list of mohols outside reserve forest under Karbi Anglong. Working period is 3 years.
3 years.
So therefore, the 3 years was when the settlement was to be made. 3 years is over. So now therefore, and therefore there must have been some delay. So there was given for only for 2 years. So they have to go now. Another problem is whether these forests they can do is another thing. They are not allowing anything in view of the
Embargo.
species. That is why the respondent is not bothered. You know why? Because of that, they have stopped everything in view of some Supreme Court judgment. Anyway,
So
that-
illegality will be.
Huh?
The impugn order will be set aside. That is the only relief. Otherwise, nothing. Absolutely.
in fact, the period is also on.
Period is gone and value is supposed to increase. All these angles are there, very much there, my lord. I understand. But even then, so far validity period is concerned, so that deficiency also there in the tender, public tender. When the time is an essence, so far this sort of public tender is concerned, that ought to have been, I mean, taken into consideration while publishing it. But all these things were omitted by the authority. And it was before this
Sir.
honorable Asham.
So and so the learned counsel appearing on behalf of the petitioner. Miss Mr. D. Gogoi appears on behalf of the respondent number 1, 6 and 6? No,
6, I'll be appearing, Lordship.
respondent number 1. Miss so and so appears for respondent number 2 to 7,
2 to 6,
2
Lordship.
to 6.
7 steps has not been completed.
The present petition has been filed by the petitioner, assailing the undated order issued by the respondent number
May
3.
may I please your lordship?
Respondent number 3 to the respondent number 4, whereby the
I beg your pardon, lordship. This undated order was later on rectified by filing this additional affidavit. So
filing
that may be looked into. Additional affidavit was filed in order to bring the
order dated
original, the copy of the original order.
12
where
three-
date is mentioned.
Huh?
13.
What is the date?
13/3/2020.
13/3/2023.
13/3/2023.
Issued by the respondent number 3 to the respondent number 4, whereby it was informed that the authority of Karbi Anglong Autonomous Council, DIPU, had accepted the highest bid amount of rupees 15,50,000 against the government value for rupees 8,40,000 for 6,000 meter cube sand for the period of 2 years offered by the respondent number 7 against the Jamuna River and Mohol at Upper Hatipura sand contract lease area under Karbi Anglong West Division Difu. Full stop. The petitioner immediately on coming full stop. The brief facts which led to the filing of the instant writ petition is that a short tender notice was issued by the respondent number 6 for settlement of various mining contracts. Amongst the mining contract areas, one of such area was Jamuna River, San Mohol, Hatipura. The petitioner participated in the said tender process and upon carrying out the tender evaluation, the petitioner's bid was found to be technically competent as well as the petitioner was the highest bidder. However, the respondent number 3 have written the impugned letter dated 13/3/2023 to the respondent number 4 for settling the contract in favor of the respondent number 7 by mischievously mentioning that the respondent number 7 was the highest bidder. It is under such circumstances the present writ petition was filed. This court duly takes note of that the learned coordinate bench of this court by an order dated 24/3/2023 issued notice and further directed the maintenance of the status quo with regard to the matter of allotment of the sand mohol in question. The writ petition thereupon has been listed today after more than 3 years. This court finds it very relevant to take note of that the impugned order that the respondent authorities have not filed the affidavit. And under such circumstances, it shall be deemed that the respondent authorities duly admit to the contents, the statements made in the writ petition by applying the doctrine of non-traverse. Be that it may, this court also finds it relevant to observe that in the comparative statement, the petitioner was the highest bidder and was further technically competent. However, the respondent number 4, respondent number 3 have written the letter to the respondent number 4 by placing inaccurate and incorrect by placing inaccurate incorrect facts, incorrect statements, making incorrect statements that the respondent number 7 was the highest bidder. This court also takes note of that in view of the order passed by the learned coordinate bench on 24/3/2023, the period and whereby there is a direction of issuance of a direction for status quo. there has been no settlement so granted in favor of the respondent number 7. The impugned communication is also mentions that the settlement was proposed to be granted to the respondent number 7 for a period of 2 years. Under such circumstances, for the reasons aforesaid, the communication issued by the impugned communication issued by the respondent number 3 to the respondent number 4, dated 13/3/2023, cannot be sustained in law. Be that as it may, this court also finds it relevant to observe that the period for which the short tender notice was issued had expired. And under such circumstances, there would now be a requirement for issuance of a fresh tender for settlement of the said mohol, Sen Mohol. Accordingly, the writ petition stands disposed of with the following observations and directions. The impugned communication issued by the respondent number 3 to the respondent number 4 dated 13/3/2023 is set aside and quashed. Number 2, the respondents the respondent numbers 2 to 6 would be at liberty to take effective steps for settlement of the said mohol by following the due tender. Because for Karbi Anglong, we can't say due process because they may mean anything. So,
Fresh. Well, my
only
submission,
probably a tender process.
my submission with regards to validity of rate, whether that can be incorporated in the
Why?
fresh tender.
Not necessary.
Obliged.
Lordship had directed the PhD council to obtain instructions regarding the demand.
Ramesh said, no? Well, no updated instruction as such. my lord. They have sent the old instruction whereby my lord, the fund demand was sent and rejected.
Huh?
No. Oh, fund demand was sent, my lord, up to only the. The chief had sent to the secretary the fund demand, my lord, to the tune of 4 lakh something.
Then
And then, my lords, today I don't have any updated instruction.
The fund demand was first sent on 2/4/2024.
fund demand was sent by the
Chief engineer.
Robert, let me look after. Chief engineer.
Chief.
this court duly takes note of that the chief engineer PHE Assam had submitted a fund demand to the secretary to the government of Assam Public Health Engineering Department. On 4/6/2026. When the matter was listed before this court on 27/7/2026, this court inquired with Mr. I. Bottakur, the learned standing counsel for the PhD, as to what transpired and what steps were taken for as regards the demand proposals so made to the secretary to the government of Assam Public Health Engineering. At his request, this court fixed the matter on 12/8/2026. Mr. D. Gogoi, the learned counsel who appears on behalf of the respondents, submitted that though the fund demand was submitted on 4/6/2026, but there is no correspondence from the secretary to the government of Assam Public Health Engineering Department. From the above, it is therefore clear that on account of the inaction on the part of the secretary to the government of Assam Public Health Department, The order dated 5/4/2024 passed in WPC number 2455/2023 have not been complied with. Considering the above, what's the name, Secretary? You know, no?
Gitimoni Fukon.
Huh?
Gitimoni Fukon. I'll write in paper.
Considering the above, it therefore transpires that the said Secretary of the Public Health Engineering Department is intruding into the compliance of the order passed by this court. The said action on the part of the Secretary undermines the rule of law. Accordingly, this court being prima facie satisfied impledes, and I'm to read you, so and so, Secretary to the Government of Assam, Public Health Engineering Department, Dispur, Gauhati 781006, as the respondent number 4, respondent number 3.
Five. We filed the amended cost title earlier.
The respondent number 5 to the present proceedings. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court, and the registry on the basis of the present order as well as the memo of parties make necessary correction in the cause title of the contempt proceedings and update the same in the CIS. Issue notice upon the newly impleaded respondent number 5. Steps be taken by speed post returnable on 9th of September 2026. Steps be taken by speed post upon the respondent newly impleaded respondent number so and so by tomorrow. This court also grants the liberty to the petitioner to take steps upon the respondent number newly respondent no by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. First, the newly respondent number 6 shall apprise by way of an affidavit on the next date as to why contempt proceedings should not be initiated against the said respondents on account of not taking effective steps for compliance to the order passed by this court dated so and so in so and so. A copy of this order be also enclosed along with this order will go, na?
This order will go, Lordship. Obliged, my lord.
What has happened? None appears on behalf of the petitioner on call. Pusto. The petitioner have also not submitted the amended cause title. Accordingly, list this matter upon the amended cause title being filed.
Made page, Your Lordship. Lordship, in this matter, amount has already been released, Lordship.
What?
Amount released, Lordship.
You got the relief? Okay. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that the petitioner have already been paid the contractual dues, and as such, nothing further survives. Accordingly, the petition stands closed as infructuous.
Obliged.
Yes.
Ship. The issue pertain, my lord, the allegations made by the petitioner is that, my lord, that the LOI has been issued to respond number 7 for operation of the retail outlet, my lord, on a government land. My lord, that,
Who are you?
I'm for the IOCL, my lord, we have IOCL. We have
Ah.
filed the affidavit clarifying, my lord, that the governments are not correct.
So now you are
They are
like Mr.
operational.
B. Gogoi and all. IOCL, you appear for CGSE and IOCL and what not.
Ma'am.
So next time, what not? You are holding the fort for the central government and IOCL.
My lord.
And B. Gogoi is for holding the fort for the state government and oil.
Oil.
Fantastic. Nothing remains for others. Yes, tell me, what is your case?
Lord, we have already clarified, my lord, in paragraph, page 57, paragraph 6.
Hey, the petitioner is not
It is
represented.
not represented. Already this outlet is operating, my lord. It has become operational. He was
It
an,
has been given to somebody.
yes, that was under challenge. Respond number 7 has been given the LOI. That was put to
Mr.
challenge.
H. Gupta, appearing on behalf of the IOCL, submits that the respondent number 7, upon being granted the IOCL, granted the settlement,
Yes.
award of the retail outlet, the said retail outlet is presently functioning.
Okay.
None has appeared on behalf of the petitioner on call. For the ends of justice, the matter stands adjourned to be listed again on 3rd of September 2026. 2nd of September 2026. It is observed that in the circumstance the petitioner is not represented on the next date, the writ petition would be dismissed for non-prosecution. Yes, what is this? Video conference? You got the money?
My lord, payment has been given, my lord.
And my lord, the undertaking
Security
is-
deposit amount has been paid, my lord. I have instruction not to press on the interest part, my lord.
Yes. Is given the undertaking. my lord.
The petitioner have already received the amount of security deposit to the tune of rupees 27, 25, 344. Insofar as regards the question of interest, the petitioner had given an undertaking that the petitioner could not claim the same. And in that regard, the learned counsel appearing on behalf of Mr. B. Gogoi, the learned counsel appearing on behalf of the respondent, have placed the said documents which are kept on record and marked with the letter Y. There's one matter, two matters.
Two matters, my lord. Item 23 and 24, my lord.
We are concerned with
23, my lord.
161 at Y.
161
For
is
which
the
accordingly, the contempt proceeding stands dropped. The other will be same.
Same, my lord.
Why? Itu dia. Ada tak sini ki? Same order types. Itu amount will be different, huh? 41, 37, 25, 280.
Obliged, my lord.
Agaknya itu ke semua. Itu Y.
This, your lordship, matters is arising out of the award passed by the industrial tribunal, your lordship. For your lordship, we have filed a petition seeking
They have filed that IA for under section 17B. But in the main case, my lord, the pleadings are over. So matter may be taken up for final disposal.
So you filed IA.
No, I have filed I. For your lordship, under 17B, your lordship.
Oh.
Lordship. If your lordship hears the entire matter, your lordship, this is.
Why should we hear the entire matter?
Lordship.
Is in the case of reinstatement.
Yes.
Yes.
You have filed your objections?
Yes.
Is he working?
No. He's terminated.
He's terminated. Somewhere else, yes.
17B
Yes, yes.
working or not. That is the only question. If
Lord.
there is nothing, we have to allow it. That is the mandate of law. It is your burden to show that he is working. He's
My lord.
gainfully employed somewhere else.
My lord, today I'm ready to argue this case, my lord.
Which one?
The entire matter, my lord.
Why should I hear you? You maybe are ready.
Because-
Why should I hear you?
Because
It's a
on-
case pertaining to award. You're challenging the award on what grounds?
I said that he is not an employee under the definitions of this Employees Compensation Act.
Huh?
He does not come within the definition of employee.
Workman.
Workman under Industrial Disputes Act.
Why?
Because from his appointment letter, it clearly shows that he was drawing a salary of more than 30,000. So here, as per the act, if he is in a managerial position and he is drawing salary more than 10,000, so he does not come within the purview of workman. So there is a judgments rendered by the Honorable Supreme Court, which I am relying on. So, and in that aspect, in such view of the matter, that proceeding is vitiated.
And how does the tribunal take into consideration the
That was not considered.
Did you raise that objection in your written statement?
No, but
Then
only
Why should we look into that?
only there is
question.
one cross
Because
examination.
obviously the question is, if you have not raised, you have not filed the document that he was earning so much.
That is part of the record. The appointment letter itself is part of the record that clearly shows that he was these two things, that he was in managerial position, and number two, that he was drawing salary more than 10,000. And there was cross examination on this point.
And Industrial Disputes Act is only for between
Employer and employee.
sure. When can an industrial dispute happen? You'll be there in the Industrial Disputes Act.
Yes.
It's between employer and employee, not employer and employee. Then obviously this will come in. He's an employee.
Employee, but there is a stipulation which says that he has to this one, my lord.
When can an industrial dispute arise? When?
When there is a dispute between employer and employee.
Only. Only that. There is a mention out there how it will rise. It is mentioned there. What is an industrial dispute? Read there. What is the definition of an industrial dispute? Not ready.
Industrial
No.
dispute means any dispute or difference between employers and employees, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment, or the terms of employment, or with the conditions of labor of any person.
Now my question is, it's an industrial dispute, employer and employee.
Yes.
Why? What is the problem?
But the definition of employer, workman, my lord.
Why you are going into workmen? It's an industrial dispute, can be referred. Is it that the labor court's power is only as regards industrial dispute? It can decide an industrial dispute. Definition says what? Read it properly, Mr. Bhattacharjee.
My lord.
Employer and
Employee.
employer and workman.
Yes.
So you are saying that it is a workman. He's not a workman. He's an employee.
Yes.
Then how does it matter?
That is the only point I raised.
That is the only point. Read it properly. Then you will get it. There is another ground. Find it out.
Well.
I'm not here to help you out, but there are two judgments of the Supreme Court on that point. Then what he requires, if he is in the managerial cadre, then where he goes? He has to file a suit, isn't it?
Yes.
What is the name of the judge, madam?
Lenin, there's one.
Ah,
This is Lenin Kumar Ray. This is the leading judgment at this point, I find.
Lordship, so far as that point is concerned, your lordship, that was not your lordship with the terms of reference, whether I am a workman or not. That has been not been raised by them, and in fact, your lordship, in their WS, in their evidence, they have admitted myself to be an, your lordship, workman. Categorically. That they have entire evidence, entire WS, they have stated me to be an workman, your lordship. Now, after admitting that on their own, your lordship, whether they can raise that plea before this honorable court, your lordship. Then once your lordship go through that, their evidence and their WS, your lordship will find they have admitted myself to be a workman. The word workman is specifically used by them in both. And they have not raised this issue before the learned tribunal. And in fact, your lordship, terms of reference, this is not an issue, your lordship, framed, whether I am a workman or not. And the industrial tribunal, your lordship, cannot go beyond the terms of reference, your lordship. That's the settled principle, your lordship.
prepare.
Lordship, may kindly
You are
grant me one
mostly
day.
busy with revenue.
My lord.
You're mostly busy with your revenue matters. So prepare on the industrial disputes. Read it, but read that. Have you ever gone through the book of O.P. Malhotra?
No, my lord.
That is the foundation. That is one of the best books on industrial law. Read that. It's a very interesting and I think one of the so beautifully written book. A 2-volume book. Read it. What is an industrial dispute? How can you raise? All these things are given. But this is the law which is, although now it is there, but law was developed sometime around 65, 70, 77, 80s. These are the law which was there. Now it is going on, but nowadays you don't have even cases of industrial disputes. Very few. Yes. I'm told lots of the industrial tribunals are just no work out there. But at one point of time, there used to be so many cases. Therefore, see that book. Find out whether it's an industrial dispute or not. Fine. We have it on another day, on a Tuesday, so that on that day we can either finish it off or allow your 17B.
Lords.
List this matter again on 10th of September 2026, on which date the court shall either make an attempt to dispose of the writ petition, and in the circumstance the writ petition cannot be disposed of, the interlocutory application shall be taken up for final disposal. The registry shall list the interlocutory application under the heading application under section 17B of the Industrial Disputes Act.
এইবিলাক কথা একোৱেই নাই। Workman মেলিলে হয়।
If item number 26 is called, my lord, I appear for the respondents.
Productions.
Item 26, I am for the respondents, my lord, bridge and roof.
Item number 26, this is a different matter.
I
Mr.
apologize,
Counsel.
I apologize.
Yes, who appears in this Jobeshwar Boros case? Yes, what is your case?
Yes, my lord, in this matter, my lord, the petitioner, my lord, participated as per the NRT dated 27/5/26 for the weekly market, my lord.
Lordship will find that NIT at page 15, my lord.
Hmm.
That is on 27 May 2026. And Lordship will find in the very close in NIT, close number 13. I am the highest bidder, my lord. And Lordship will find the comparative statement as page 40, Annexure 3. Next are 2 series my documents I submitted with NIT. My name, Jobeshwar Boro 1, my lord. The schedule rate is 1,83,683. By I preferred offered 5,03,000 and private respondent offered 4,39,000, my lord. And my rank is 1 and 2 is the private respondent. That MP order Lordship will find at page 44. Starting without intimation, without reasoning, without informing me, my lord, this approval order passed and settled the weekly market in favor of private respondent number 5. That on 27 July 2026.
PNRD or BTC PC na?
Oh, aaj copy this. Copy this too.
BTC or PNRD?
PNRD copy this. And copy this. When we approached before the block authority, then we came to know about this fact. Then we approached this court, my lord. They ought to have been why my case is my tender has not been considered, nothing has been intimated to me, though I am the highest bidder, my lord. And that is the weekly market in Friday only, this market, my lord, for 1 year terms. And in the impugn order, Lordship will find at the bottom, no copy has been served to me, in fact, for non-consideration of my case.
This tender notice is for what?
For my lord, settlement of weekly market, my lord.
How do we know for your market is there?
Yes, my market is, my lord, it is Lalpul Open Weekly Market, Annexure 2, page 18.
This is your application.
My application, this is the
But
market.
where is it mentioned out there in the tender notice about this application? This is done by whom? BTC?
My lord, yes, Council, Market Council, Bodoland Territorial Authority.
BTC, have you served notice?
My lord, at the time, copy, my lord, filing, my lord.
Notice this and BTC, so.
Unlisted. BTC copy serve করেছে.
You informed that the matter would be taken up today.
My lord, that, my lord, BTC
Your
Council.
notice does not
Yes,
say
yes.
so.
Yes, my lord, I will inform then, my lord, BTC Council after some time, my lord.
Then after some time only the matter can be taken.
Lord, sir, kindly after some time, my lord, in the meantime, I will.
And more particularly, where is your, that particular, this is done by the panchayat?
Not under Panchayat, it is block, my lord. It is not unselect from the Panchayat, my lord. It is under the, in a portal tailor, their block, it's our competent authority, my lord. In the very, it is clear, my lord, in the impugn order is fell. BDO is the concern of.
And the panchayat does not apply there, na?
No, my lord.
Okay. Hey, the ticker devolution asking the BTC council to be present. We'll take after
Yes,
some
my lord.
time.
Please, Your Lordship. My lord, this petition is against a peculiar and deliberate attempt by the respondents to exclude any chance of participation in a government tender by me and persons like me. My lord, the facts are slightly like this. Under the National Food Security Act, my lord, the free rice is distributed through fair price shops to the BPL card holders. Lordship knows about it. For that, my lord, every district, the deputy commissioner, nowadays it's commissioner district, is empowered with the task of selecting and appointing handling transport contractor for loading rice bags from various Food Corporation of India depots, and then to take them, transport them to the GPSS, my lord, wholesale consumers cooperative societies. That is the phase 1 of the work. In the phase 2, they are to transport it from the GPS go downs to the earmark, my lord, hundreds of fair price shops all over the districts. And the deputy commissioner of a concerned district is empowered for the territorial jurisdiction of the action. Now, as against other districts, my lord, so far as Nagaon district is concerned, mysteriously, my lord, for last 4 years, 4 particular tenderers and farms have been allotted without NIT, this work. And there were naturally hue and cry, newspaper reports, etc., my lord. I will not refer to that. Then, my lord, ultimately this year, the district office of Nagaon deputy commissioner, my lord, issues an NIT, which your lordship will find at page 22. Page 22, NIT. It starts both technical bid and, my lord, tender document, transport contract for implementation of doorstep delivery. Lordship may have a look at page 23. Page 23.
So you are challenging what?
I am, my lord, have a look at, my lord, page 23. It says 2 things. Tenders invited from so-and-so, transport contracts having geographical knowledge of the district. Lordship may just keep it in mind. And then the schedule is given. Now, my lord, kindly have a look at page 46.
Yes.
The conditions, page 46. Particular condition has been given by way of a corrigendum. Existing provision was for 2 years, that was reduced to 1. Now I am reading the revised provision. Bidders must have, below, revised provision. Bidders must have minimum 1 year experience of transportation of food grains under NFSA, National Food Security. The bidders has to have submit experience certificate concerned district commissioner and additional district commissioner mentioning the period of working. 1 year, but this means one has to have experience of transportation of food grains only under the NFSA, not otherwise. No other transport experience, be it transportation of food grounds under the statutory authority like FCI or civil supplies or flood relief supply, which I have excluded. It says only you must have 1 year experience of doing this work under this scheme. So, my lord, this condition is, my lord, absolutely disgraceful, my lord, untenable both in law and facts. I will show you for 1 to 3 reasons. Number 1, there are transport contractors like me who have vast experience, my lord, of handling transportation under similar conditions. The nature of the works are similar. Lordship may kindly have a look at page 40-41. What is the nature? Page 40, Lordship. All loading point, transport food grains, top of food storage depots, all are from lifted to be lifted and transported from various food storage depots within the district of Nagaon. And they are to be delivered at the destination points, which are the Gram Panchayat Samabay Samiti go downs. And the respective distances are mentioned. 45 items till next page. That means 45 works. Then the next page, your lordship will find page, this is the second phase, tier 2. It mentions the loading points at the second stage of the various go downs under the GPSS and the delivery destination to various fair price shops, some 15 kilometers away.
Now you don't have NFSA.
I don't have it. Incidentally, my lord, other districts are not imposing on this. Also, kindly have a look, my lord. My experience, I have kindly have a look at page 47. Can there be a particular page 47? It is, my lord, for very recent, my lord, this month, August, Bongaigaon.
24.
Bongaigaon, August 26, my lord, this is the latest one issued by the district commissioner. Same, my lord. For transportation geographical knowledge for transport contractor under NFSA 2013. This is the name of the, then lordship may kindly turn to page 50. Page 50. Terms and condition. Lordship may kindly go to clause 4. The bidder shall have experience in transportation of food grains as handling and transportation. General. It doesn't specify that it has to be NFSA. Page 40, page 50, clause 4. Bongaigaon district. Say more, the bidder shall have experience in transportation of food grains of handling. It doesn't say that one must have the transportation experience only with respect to NFSA scheme. And then another district, lordship, kindly come to my lord, page 58, Golaghat district. It is bordering Nagaon. Page 58, lordship. No. Page 58, kindly Annexa 5. This is from the district commissioner. Same handling transport under NFSA. Now kindly turn to page 60. The condition. It is also of August. Latest. Page 60. Page 60. Here again, paragraph 4 of the terms and conditions. Bidder shall have experience in transportation of food grains as handling and transport contract. So can there be, my lord, a specific insistence clause only in Nagaon district? No. And one is required to have, my lord, geological knowledge about this thing. For last 4 years, I could not, naturally in absence of tender, I and similarly situated, my lord, contractors of Nagaon district, including these petitioners, they could have, my lord, gathered any experience in Nagaon because there was no tender for last 4 years.
There is no necessary for the Nagaon district. What is the stipulation is that you have to have 1 year. Earlier it was 2 years, now they have reduced it to 1 year.
But the condition that you must have the experience of
NFSA.
doing, yes, that is.
So what is wrong? You are going to do NFSA.
No, my lord. The question is, this cannot be fulfilled by the Nagaon because last 4 years there are no tender.
Is it required that it has to be from Nagaon? Anybody who has the Nagaon area, it is enough.
Look.
Conditions does not specify that it is the NFSA has to be the experience from Nagaon.
No.
No,
Maybe from-
because in the other conditions also, it also mentions have to have the area of the particular district. Kindly see that the other districts also. say that.
Others
So
are not met.
therefore, so and so has to emanate the DI, it says the bidder should have experience of handling areas, so and so. This will be done.
Not under the Bongaigaon and Golaghat, kindly see, I have shown, my lord. Am I clear, my lord? Page 60, clause 4. So far as this Golaghat district, it has not said that I must have, my lord, experience only under NFSA. It said I must have experience
Now,
of.
here, they say that it is only for the NFSA, 1 year has to be there. That's
But
it.
this is not there in the, my lord. The other,
See, they have not done it. The South Salmara or no, Bongaigaon have not done it. That doesn't mean that this condition can be set aside.
No, my lord. This is actually only to me, my lord, to me. And Nagaon also in the background that last 4 years no tenders.
There is no requirement of Nagaon having anybody else.
But
that you have to have the NFSA is strictly limited to Nagaon.
But
you want a clarification, I can give a clarification to the effect.
But the question is, this is under a scheme, my lord, uniformly to be followed by the various districts, my lord. This is a state. This is for the state. Various district territorial.
Because the Kokrajhar one is of the year 2024. We are in 2026. Bongaigaon is of 2026.
Now I have shown, my lord, 2028, 2026 of both Nagaon for the first time after 4 years and also Nagaon, Bongaigaon and Golaghat.
No, Golaghat is of the year 2024.
24. This is of 2020. 26. So therefore, my lord, what
You are here to carry transport of NFS. So they require 1 year. Earlier it was 2 years and 5 years. Out of 5 years, 2 years. But now they have said that whatever may be, 1 year experience of NFSA is required. So what is wrong with
That
this?
is the crucial issue, my lord. Because others under the same scheme, that deputy commissioner cannot insist this particular experience that it has to be on runner. Other deputy commissioners have simply said that you must, it is enough.
Only one district has said so. Other districts have not said so.
During last 4 years, my lord, 24 comes during last 4 years, 5 years.
We are not concerned with 4 years. We are concerned with this year.
That's fine.
We are only concerned here.
That's
And this is the contract for how many years?
No, my lord, this has to be, my lord.
For only 2026, 27.
There has to be some consistent, my lord, approach by the deputy
No,
commissioner.
but the fact remains now it is given for only 1 year. This 1 year and they only require for NFSA.
And one thing,
And this is a particular contract for NFSA.
NFSC for Nagaon district. And one must have why this is written that geographical knowledge, because I must know the various, my lord, GPSs and various.
I would have understood that you have a geographical knowledge. You have a NFSA from other districts.
My lord, naturally.
Other district you have NFSA knowledge. So therefore, if you come up and
No,
say that it is there, then obviously this
And fair price shops, and the fair price shops, my lord. So there cannot be different yardsticks by different district authorities for the, my lord, same scheme and the same contract. My lord. This is, my lord, the level playing field has been reduced, my lord.
A conduction NFSA Act and the rules. Yes, Mr. Goi.
And my experience is, lordship, just 1 minute, my experience, my lord, covers.
National Food Security Act.
My experience is at last page 62. Same nature of works, page 62.
And that I've seen, it is from FCI.
FCI, my lord, is a larger magnitude, same nature of works. From FCI go downs to different destinations. So level playing field.
FCI comes from mostly it comes from, normally it comes from, FCI comes from the rail to the godown.
No, from FSDs also, my lord. Here also most of the pickups are to be from the FSDs and the destination is given. So the nature of work is same, transportation. And kindly see the quantum of works I have done. 2021, 22, 22, 23. It's a huge quantum I have the experience and I cannot participate, my lord. I cannot participate. And there is another act, my lord. There is another act, my lord, Assam Public Procurement Rule Act, my lord. Rule 12, Rule 12. Here also it said, it is sort of the procurement, my lord. Procurement includes taking service also, apart from, my lord, other things. Here, not to use or include unnecessarily restrictive or tailored specification. My submission is it is tailor-made for the 4 farmers who have been working for the last 4 years without tender, so that others are excluded. Lordship may not overlook kindly that aspect.
Yes, Mr. Gogoi.
Yeah, Lordship, how petitioners agreed that part, Lordship, to decide, Lordship. Due to the Lordship revised tender conditions, how petitioners agreed, Lordship?
Because he does not have NFSA experience.
That part cannot be. It is up to the Lordship tendering.
He says that in other districts, you are having different things.
Other district, the authorities defines for Nagaon district, Lordship. It is the tendering authority, they have to decide, Lordship, what is suitable or what is not suitable, Lordship. They have not deprived, Lordship. Anybody was not deprived. Level playing field is equal for all, Lordship. And if we go by that proposition, Lordship, then the tendering authority cannot impose a condition also, Lordship.
Where is that rules? There used to be a rule, no? Food security allowance rules. Where is that rule by which these contracts are being allowed? What is the name of the rule?
My lord, some public procurement rules, my lord.
Huh? No, no,
Assam?
no, no. There's another rule.
Central rules, Lordship.
It's a central rule,
Central
but
rules, sir.
what is that rule name? I don't have that, my proper person, which we normally do.
Central.
No, whereby these payments are being made to the fair price shops and all, where is that rule?
That rule is.
This is under Food Security Act, my lord, every state is allotted with some fund. And my lord, the implementation and the beneficiaries, it is for the state.
Yes, sir, 13, Lordship.
No, got it.
I'm saying again.
Now, we had a lot of cases as regards agent. There's a definition of agent somewhere. I forgot the name.
Here in Assam, my lord, it has to be under the Public Procurement Act and the rules.
No.
There also it is clearly mentioned that you cannot restrict the field of prospective bidders and participants. And discourage, my lord, wide competition by making tailored specification and terms of reference. That is what, my lord, Rule 12(3) states, my lord. So state must act, my lord. State action cannot be, my lord, different yardstick for different, my lord, deputy commissioners.
Oh, there's another one rule there. Yes, Mr. Roy, there used to be one, there is one rule, I'm not getting it, whereby the handling contractor is being appointed. There is a rule 7 which specifies how it is to be done. And more particularly rule 7(6), wherein it says, because there are many cases where this fair price shop says that instead, forget about this handling contractor, let us go and get it from FCI. Because it is to be only by the state or his agent. An agent has been defined to be a cooperative society. Where is that? Which is this rule? There was a big litigation which was carried out by Mr. K. N. Chaudhary on one hand, Mr. D. Nath was on the other hand. In respect to one wherein a contractor was appointed whereby he was not a cooperative society and the government was taking steps for appointment or giving appointment to private individuals. This was put to challenge, and therefore there was a direction passed by this court. I think Justice Nair passed that order to change it. They changed it. What is that rule?
Just I try to remember also that.
Because it is the contractors are appointed on the basis of these rules.
Yes. It's a preference to cooperative societies as against, my lord, individuals. I think that is what your lordship is indicating in that rule. But kindly have a rule at this procurement rule, my lord.
No, procurement rules doesn't come into play.
If it, my lord, because it includes, my lord,
Procurement rules has
by way
no
of the
limit.
definition clause, it includes taking service. So transportation is also a service, my lord. I respectfully submit. And
And the agent has been defined. And the who can do it, the handling contractor has been defined either by the state or by its agent. And the agent is defined as the cooperative. Therefore, we have these cooperative societies doing all these things. And if it is the cooperative societies, then can these be issued in respect to them for transportation from FCI to so and so to the fair price shop? It is done by the cooperative society. Wouldn't your very notice inviting tender?
here, my lord, it is to be done by me, my lord, in two segments. First, I am to take it from the FCI go downs to the GPSS go downs.
Understood.
Second
but-
step.
But my question is not that.
Lordship.
Can this type of NIT be issued to ask anybody to participate? That is, it has to be only by the cooperative society or by the state. Where is that rule?
It is the.
Yes.
After some time, also, answer.
Just find it out.
Yes, I understand. The second limb of the work.
No, the first limb of the work also.
First limb, from FCI to cooperative society, I transport.
No, nobody get.
Then
it is only by, because you see, this is a amount being paid by the government, by the central government at a ratio. Now, out of this particular amount, the assistance which is being provided, and therefore you have to follow the mandate of that central rule. Now, the central rule says that it is this transportation which is required to be made from the FCI go down to the cooperative society, or cooperative society to, actually, all these things are not there. They will have it to the cooperative society because they have it. If there is a transportation to be carried out, it will be only done by either the state or by an agent. Now, agent is the cooperative society. And if it is so, therefore the private individual cannot take it.
Yes.
So if that be so, then nobody can get it other than the cooperative society.
if that is the law, my lord, the private individuals are out.
Because there is already a judgment passed by to that effect. Ask Mr. Dinath, he knows. I forgot the name of the rules.
Is my lord has.
I therefore closed that matter whereby there was an initiation and asked them to go for a fresh tender for that. I remember that. So if that be so, this is a handling contract. So therefore it cannot be by this way.
Private individual or private.
Private individual, how can they come in? This is an important aspect which needs to be looked into. Let us have the rules first.
If, my lord, that is the position, they cannot float tenders like this.
You also lose your locus.
And what if there is no cooperative society?
No, then the state will do it by itself. That's the rule. Otherwise, you see, the state is getting an assistance. The central government is providing an assistance of 110 rupees or something to that effect. And this 110 or 115 rupees which is being provided per quintal or something to that effect is only being provided so that you carry out this. And now this has been extended to 170 rupees. Then the central government would not make a payment. And then how will the state pay if they don't follow the rules? And apart from that, the state is only the implementing agency. State is not the authority. All these things is being done by the center. The center's food. Food is centers. Center wants this to go to the fair price shop so that the fair price shop distributes. So in between, it is the what you call the state who comes in. So state can do it by themselves or by a cooperative society.
Can it do it by way of a tender like this? That is the question.
If it cannot, the matter ends there. We close it. So that we find it out because
As per Dibrugarh.
so therefore, if we issue this type of notice, then it will have a far-reaching consequence. So therefore, you just get that.
Even the number.
There will be a time limit for submission of tender tomorrow. Tomorrow, my lord.
No, today.
Yes, my lord. Yes.
Today it goes either this way, dismiss it, or dismiss your petition. Either way.
My lord, the question is not only my.
Because Mr. Barber, I make it very clear, I'm not satisfied with your submission. So the only way is for me to dismiss it so that you can immediately go to the division bench. Your last date of submission is of 18. No, I'm telling you, I make it very clear. I'm very clear on this. Your next date of submission is 18th. So therefore, if I dismiss it by today, 13th, you have the opportunity of approaching the division bench by 15th.
I don't think, my lord.
2015 rules also. National Food Distribution Rules 2015 also. 2015. That particular case is Lahual Samabay Samiti, my lord said.
Food
Distribution.
here we don't have that. The food
After some time,
distribution.
After some time.
After some time. Yes, Mr. Boro.
That's right.
Yeah, Zobesol Boro. You wait for some time, Mr. Boro. Yes, what is this?
Lordship, in this matter, we are not aware that this matter was fixed and approved.
It's okay, now you have the copy. The government, somebody has taken the copy.
Two copies served to
Lordship,
them.
as there is interim order, some 27 July settlement order was challenged by the petitioner lordship. 2 days time may be given to us to take instruction, proper instruction. After that, if they are liable for interim or any other order, they will get lordship, because we are not aware of this. The matter was
If
fixed
a
with two, lordship.
settlement has been granted,
Yes, lordship, on
it can be
27.
subject to the outcome. And if no settlement granted, don't do it till the next date.
Lordship, Lordship, we have to go through the case record, lordship.
So what? It won't
To
happen.
this
No,
time, lordship, because, lordship,
Madam, no heavens is going to fall if it is so. Because of the fact that here the Panchayat Act does not apply. That
Yes,
is why I was looking into it. If the Panchayat Act applies, then the last 3 years, Rule 48 would come into picture. Now here the Panchayat Act does not apply. But only problem which I am having, Mr. Counsel,
Lord.
is where is in the notice inviting tender as regards your thing.
My lord, in the comparative statement with the net market.
No, again, not the.
My lane is.
Where is the area of Lalpur open market in the tender?
It is in the block of Milot.
Where is that? The entire tender is not here.
In the Besamari development block, it is Milot. The
Huh?
Besamari development block.
Eh,
This is in my very application, Milot.
No, forget about the application. Show me in the tender notice.
Tender notice, it is not there, Milot.
How is it possible?
That is in comparative
But,
statement, it is there, Milot.
Tender for which market?
Milot, it is reflected in comparative statement, Milot.
Understood, but which market? Tender has to say some market.
My lord, it is overall all, Milot, it is very beginning, Milot, it is the intending tenders for settlement markets, Hearts, marketing like this manners, Milot, they have, it is NIT issued, Milot. And we are for the Lalpur market, Milot, weekly market. No specific name, it is there, Milot. So in the comparative statement, Lalpur market, we have
Still tender so and so in the are invited for so and so for Iman. The tender would be received by 15th of June. And will open at 2:30 and so on 18th of June.
Yes.
From so and will open at so and so. In case of unusual occurrence like strike so and so. Now here is the case where have to deposit the offered rate. But how do we know that this is your market?
My lord, my lord, Lalpur market is that under that block, my lord, very much, my lord, reflected from the comparative statement, my lord.
Huh?
This is Lalpur openly market. I have
Find out that
participated.
thing. No, it doesn't seem that this market is here.
This is the on this NIT, my lord, to have participated.
The NIT is selling something.
Yes.
What is it selling? NIT sells something.
My lord.
What is the NIT selling? Tell me. Is it selling some market? What is the name of that market? My question is that.
That, my lord.
That is your lordship, 2 days time. We'll verify and then lordship.
Milord, some NRT, Milord, some more pages must be available, Milord. It is continued only for last page I am having. Whole NRT I will collect, Milord. Whole NRT I will indemnity and collect.
Okay, you bring it Friday.
I'll
Let's
try,
have it on
I'll try.
Friday.
Yes, Milord, I'll
Because
try.
anyways,
Yes,
there is already a delay.
yes, Milord.
The order was passed on 27/3,
But-
22/7.
No, but then same has not been.
No, anyway,
completed.
22/7, if it is passed. So therefore, 27/7, we have to almost 15 days have done.
On 7th, Milord, on 7th or 8th, we came to know about this. Then immediately we approached this court.
Understood, but then also it was not a case of an unlisted.
And Milord, yes, I understand, Milord. Had it been intimated me earlier.
Unlisted when heavens would fall. The heavens is not falling, we are still rolling. Let's have it on Wednesday, Friday.
Friday, Milord.
Taking into account the dispute involved, this court is of the opinion that this is not a fit case for taking it up as a production list in the production list. So accordingly list this matter on Friday.
Friday.
Friends,
Master bless.
motion. Ms. N. Chaudhary appears on behalf of the respondent, BTC.
Obliged, Lordship.
Yes, Mr. Dinath.
Lordship, I have given.
What is that?
My lord, so
No, that I know, but I'm saying, Mr. Dinath, you see, tell me one thing. Now, this is the tender being challenged here. This tender, a challenge has been made on another ground. The other ground on which it is challenged is that the condition is restrictive. That is beside the point. My question is, can this type of tender be settled with an individual in view of that judgment and more particularly in view of this?
The Lordship has passed an order that it has to be, if it is a cooperative society, then we can go ahead.
So can this be, so this tender, have a look at this tender. And you remember you appeared in that matter. What is this rule?
Well, that is targeted public distribution order 2015. In para 4 of that order, para 4 last part, targeted.
What is the no? Targeted, yes. Now I get it. Targeted Distribution Control Order 2015.
15.
Now this says that it will be only done by cooperative society.
By authorized agency.
Authorized.
And that authorized agency, my lord, we have said that according to our interpretation, authorized agency means a contractor also. But Lordship has said that no, that has to be a cooperative society.
It has to be by government. So under such circumstances, can this notice inviting tender be issued?
But I have not gone through.
Because apart from that, there initially, if you remember, before I said so, Justice Nair said so. And therefore, the person whom you have appointed, he was removed.
Lordship.
And thereby you gave it to a cooperative society.
Lordship.
And I finally concluded these proceedings by this judgment.
Well, this is the interim order. Lordship thereafter has disposed of.
That was by way of an interim order by Justice Nair. So then, tolo tahok sun okuman. Tolo tahok. Tolle ahok sun. Under such circumstances, whether a private contractor can be permitted to implement the act of in terms with 7 of AI, it is tolo tahok. It is the opinion of this court that if a cooperative society is granted, nothing would further survive in the instance. The opinion is based upon the submission of so-and-so, so-and-so, accordingly so-and-so, the meantime so-and-so. So therefore, targeted ekonsong, where is the targeted rules on? 2015.
Targeted public distribution.
Targeted rules ekon ase, targeted control order. Where is that? On kitabot nai no.
It is available in net, my lord.
Huh?
Available in net.
নেটত ওলাওকচোন সেই এইখন এইখন ওপৰত টাৰ্গেটেড পাব্লিক ডিষ্ট্ৰিবিউচন চিষ্টেম কণ্ট্ৰল অৰ্ডাৰ
Control order. Matter liability cooperative society, your lordship judgment. Liability cooperative. WPC number is there. Kiman?
এই বস্তুটো ওলাওকচোন So because of this handling cannot be done by private anybody else.
Yes.
Except NFS. Except the cooperative society.
That's
And if cooperative society has to, this tender has to go. Or we have to read down that this handling shall only be limited to this.
yes. If the judgment laid down by your lordship is the law, so that applies as on today, my lord. Forget about my case. There should be a mandate. And I was presenting that different district cannot play differently. That was also my second name, lordship, to challenge the tender.
এইখন চাওক এইখন ডাঙৰ
G, my lord.
অকমান
2D.
ডাঙৰ কৰি দিয়কচোন Yes. Now kindly come to authorized agency means the concerned department of the state or a body corporate or a company owned by it or a cooperative. This is the person who can do it. Now this is in exercise of the powers of public distribution order so and so. তলত আহক number 7 ত আহক number 7 তলত three উপৰত এইটো no 7 তলত আহক 7 yes lifting of gains. The state government shall lift the gain from the division of the corporation through its authorized agency. So therefore, this NIT cannot hold water in view of the law. Anyways, we have time till you look into it. We'll look into it tomorrow, day after. Else I set aside this NIT.
No, let me go through, my lord. Let us see.
Because the NIT has to be within that.
Yeah, tried it. It should not download.
Here you see, C, Roman 3, the bidder, that is the proprietor or partner or a director must have annual average of so and so during the last financial year. In so and so, the turnover limit is 5 so and so.
Basically two, my lord. Serial number 2.
Serial number 2.
If there is a partnership firm, company, there shall.
The same here, the down below also, the bidder, that is the proprietor. Now, in view of this definition of authorized agency, can this be the
To that extent, lordship, let me come back. I'll see and lordship may take up day after tomorrow.
There is a writ petition filed challenging the notice inviting tender for selection of appointment of handling and transport contractor for transportation of food grains under the NFSA 2013 for Nagaon district for the financial year 2026-27. This notice inviting tender has been issued by the District Commissioner, Nagaon. The petitioner herein, who admittedly does not have experience for transportation under the National Food Security Act 2003.
But experience matter under statutory authorities.
But has experience in other transportation contracts have challenged the amendment carried out by the corrigendum dated 31/7/2026, whereby clause 2C, capital C, Roman 1, have been put to challenge. While hearing the matter, this court inquired with Mr. D. Nath as to whether the said notice inviting tender is in consonance with the provisions of the Targeted Public Distribution System bracket Control Order 2015, more particularly taking into account the definition of authorized agency in clause 2G, read with read with clause 7 of the said order. Mr. Dina, the learned this court also finds it pertinent to take note of that in the judgment delivered in the case of so and so, এই তো আগৰ judgment to is there না লাপুলি এখন দিছিল না এইমাত্ৰ এখন
1924 of 2025.
to একদম ওপৰত আহক। in the order passed on 17/11/2025 in ওপৰলে হওক একদম ওপৰত হওক in the case of Laipuli Gaon Panchayat Samabhai Samiti Limited and 15 others versus so and so, WPC লিখিলে নহয় এই ওপৰলে হওক WPC লে হওক WPC number 1924/2025. This court had categorically held that the authorized agency, which is defined in clause so and so of the order of 2015, would not include an individual, a private individual, or a private firm or a private company, except what has been defined in clause 2G of the said order of 2015. Mr. Dina, the learned counsel, learned senior government advocate, shall look into the said aspect and apprise this court on the next date. To hold.
Day after tomorrow, Lordship.
Friday.
Day after tomorrow.
Promotion.
Sir, 26 of your Lordship's daily list, my lord.
Lordship, here in this case, I filed an appeal for prepone of the date, your Lordship, where that relevant day, the dishonorable court had passed an order dated on 2026, my lord. That day I was in the flat at my home, native place, Sipsagar, and I have also given my leave application that day.
Now, what do you want?
Prepone of the date, as Lordship accommodate.
What is the urgency?
Because my whole money have been stuck.
What money?
That contextual works, completion works have not been released by the.
Who are you,
respondent.
Mr.
My
Counsel?
lord, I am for respondent numbers 2, 3, and 4, my lord. Bridge and Roof
that?
Company. My lord,
Main
Bridge and
corp-
Roof Company. My lord, if I may indicate, my lord, we are challenging the maintainability of the writ petition. My lord, the dispute arises out of contractual terms, my lord. My lord, Bridge and Roof was a contractor for the Assam Petro.
You are
Assam
appearing for
R2, 3, and 4. Respondent numbers 2, 3, and 4.
3 and 4.
4. Yes, ma'am.
You are who? Who are you?
My lord,
You
Bridge,
are
Bridge
Government
and
of
Roof.
India undertaking.
Yes, my lord. We are Government of India undertaking Bridge and Roof Company.
And then?
And my lord, we were contractors for Assam Petrochemicals Limited. My lord, we executed certain works and we engaged the petitioner before your lordships as a subcontractor. Now, my lord, the claim arises out of the contract work. The work, my lord, has been certified. Work has been done. Now, the dispute arose later on while finalizing the amounts. My principal, which is Assam Petrochemicals, my lord, imposed certain penalties on me for my lord, my subcontractor not fulfilling certain terms of the contract, which are, my lord, the contract is, my lord, certain raw material like stone chips and sand was taken
But
from the
today I have
forest.
filed for IA application for not for the merit of the case, my lord.
Oh,
Today I just
Mr.
want to.
Mr. Gugul, you are asking for urgency. So you have to be ready. You know this court.
Lordship, otherwise I'm ready.
Ready. You should be ready. You cannot say, the moment you say that today you are not ready, I then say, why should I entertain your IA for early hearing?
Lordship.
Yes, tell me.
So, my lord, at the time of finalization of accounts, Bridge and Roof finds out that Assam Petrochemicals is claiming certain sums of money on account of, my lord, the forest department's royalty for the sand and stone chips utilized by the subcontractor. And, my
By
lord,
the?
there are certain by the subcontractor, because, my lord, I am the principal contractor. I have subcontracted the work to several contractors, including the petitioner here. Now, my lord, during the finalization of accounts in May 2024, that is before filing of this writ petition, my principal imposes
Have you
certain penalty.
disputed the amount or not,
Yes,
Mr.
yes,
Khan?
yes, yes.
Where
my
is
lord,
your
the amount,
statement out there in your petition?
but in
in
my
your
affidavit
affidavit?
opposition, kindly, my lord,
Where?
takes page my lord, 19, 19, my lord.
Page?
Page 19, 19.
There is no page 19 on.
Then, my lord, I apologize, 204. I believe it's 204. In my
Paragraph?
opposition. My lord, that's the email. Page
What is
204
your
is the
paragraph? Paragraph
paragraph.
of your affidavit.
The paragraph in my affidavit starts from page para K at 192.
Certificate and the necessary certificates from the Labour Commissioner.
Para K at 192, the disputes are written down. Then, my lord, para M 196, GST dispute is there.
What is the reply filed?
But affidavit
Yes, what
reply,
is the reply?
yes, my lord, kindly has in their reply page 207. Page 207 at 208, this para Roman 3 at 208, Lord, will find they say that they have paid the forest royalty clearance certificate. So, my lord, my submission is that this is clearly disputed questions of fact, my lord. In my humble submission, my lord,
Now, where is the agreement?
my lord, the GCC is, my lord, in the petition. My lord, kindly have page 59 of the petition is where the general conditions begin, and at page 65 is the dispute resolution clause. Page 65, clause 29 and 30. That apart, my lord.
Wait. Arbitration is there.
Yes, my lord, arbitration is there. And, my lord, the next page, your lordship will find the jurisdiction is, my lord, agreed upon as the Honorable High Court at Calcutta.
Where was the work contract executed?
Work was carried out in Assam, my lord.
How are you in Calcutta?
But my register
Well,
office
you have
is,
what in Calcutta?
but my register office is, but
Was the contract agreement entered into in Calcutta?
the letter of that was also issued from Calcutta, my lord. If your lordship may have the letter of intent,
Where is your registered office?
registered office is Kolkata. If your lordship may take one sample page, my lord, the completion certificate or the letter of intent at way 139, 139. One of the letter of intent, my lord, there are several. At 139 top left, your lordships will find Government of India Enterprise, and then registered office is located at Kolkata,
The head office.
head office.
Is the work order issued?
The work, that's the letter of intent, my lord. 139 is the letter of intent. My lord, I have to admit, my lord, it appears that the letter of intent, the stamp is the local office in Assam. But my lord, this, since the project was executed there, there was a campsite, camp office.
But there's an arbitration clause.
Yes, my lord. And my lord, the GCC clearly spells out all the obligations of the subcontractor, such as my lord, the GCC, the general clauses of the contract, my lord, spells out the obligations of the subcontractor, such as my lord, the labor dues, the forest department royalties, GST dues. So my humble submission, a lot of facts would have to be gone into, which perhaps should be done in arbitration.
So here the Arbitration and Conciliation Act will apply,
Yes, my lord.
isn't it?
Yes, my lord. That's the
It is
clause
only
29.
when there is a dispute between BNR and any other public sector undertaking, government department, bank, port trust, etc., such dispute or difference shall be referred to arbitration to a sole arbitrator of the Department of Public Enterprise to be nominated, so and so shall not apply. Otherwise, it is the Arbitration and Conciliation Act 1996.
Yes.
Yes, Mr. B. N. Gogan.
Lordship,
Dispute.
Lordship,
Dispute, how can it be settled?
during the pendency of this case, Your Lordship, filing of this retribution, they have paid an amount of the contractual amount with us. And regional registered office at Gauhati GS Road, India. If it is in dispute there, they ought to have given, not to have given my contractual amount. 30 lakhs have been paid out of 1 crore during the pendency of this writ petition.
Good.
So my
Should
humble,
be happy.
yes, I have been happy. So during the pendency of the petition, they have given the payment. The rest amount they have not paid only for the interest of filing of this.
Why should this court entertain this type of dispute? Okay.
Lordship, in this case, I had also filed.
Withdraw the IA better, not here in this court.
Lordship.
Because if I do the matter, I finish it 2 minutes. You don't need to wait till 2026 November. Get it by 3:15.
Lordship, I just give only for 2 weeks, first week of the September. Only I prayed.
It's too much. I've heard too much. Enough. This material is enough. Because I've read their thing. Their affidavit categorically says that there are on various counts. Well, there's an amount of 1 crore 40 has been taken by some Assam petrochemicals. There is certain forest royalty left, certain GST non-compliance of around 10 lakhs. All these things they have seen.
Yeah, definitely.
Therefore, they have withheld certain money from you. Now, whether this money has to be withheld or not, this is a question of a dispute between you and them. It has to be go by to an arbitration. Go to Calcutta, lovely weather. It's good weather.
My lord, right now, my lord, good weather. Rains are there, my lord. We'll welcome.
But Assam is not favorable now. In my place is unprecedented floods. So let the matter maybe fix after if lordship
No.
permit us.
I finish it off. 3:15. 3:10, 15, 5 minutes has been dictated.
No, arbitration clause in some of the judgment passed by this honorable court, where there is a, if lordship permit me, I have submitted that document. I'll show you.
Unless I am restrained by any Supreme Court judgment, Mr. Gogoi, those judgment, other judgments would not help.
I'll satisfy it. It is there.
I am not
I
satisfied.
coordinate
That's
mentioned this.
arbitration clause. You do whatever you feel like. Even under this 226, I can't make a reference. The reference has to be made only by either a court under Section 8, or in the case of that, you have to approach the Calcutta High Court for appointment of an arbitrator. That's the only way out.
I will satisfy your lordship on after if lordship permit me, because it is there in the record.
Huh?
It is there in the record why how arbitration is not also been alternate remedy of 226. I will satisfy this.
When?
Next week.
No, I can't give you a time for these type of matters.
Next week, lordship. I will satisfy.
When? Withdraw this IA.
Okay, I will withdraw.
Lord, if I may assist your lordship, my lord, the judgment relied upon by the petitioner is in the petition itself, page 39. Kindly, my lord, has page 39, para 40. Page 39, para 40 of the writ petition. My lord, the petitioner is relying upon a judgment of, my lord, your lordship's High Court, and that judgment, page 39, para 40, paragraph 40. My lord, this is Tamsher Ali and others versus State of
No,
That
I have
totally
updated-
different.
No, no,
Totally
he's
different.
not on that. He's on arbitration when there should not be a reference.
reference.
We'll satisfy your lordship. My lord, I
I'll
have
satisfy
judgments
You
where,
will
my lord,
give which
you get-
judgments? Name the
But-
judgment.
my lord, Joshi Technologies is there. My lord.
I'll satisfy.
What is the name of the judge?
Lordship. Lordship.
Name. The name is enough.
Ram Barai Singh and Company, State of Bihar, 2015-13 SSC 592,
What does it say?
226 maintainable.
Not maintainable. in these
Maintainable,
type of
Lordship.
cases.
It is there. I will show you, sir, Lordship. The other judgments also there, your Lordship.
What
where
is the case? Facts involved.
226 in these cases, your Lordship, where there's an admitted fact of the amount which has been paid by the bridge and referee. Same case is happening here in this case, Supreme Court judgment. I can show if Lordship permit me to.
Let's deliver the judge.
Sorry, Raghavan.
High
Court.
Court.
No, the reference judgments are there, Your Lordship. I can show you that judgments in our High Court.
Yes.
Referring the judgment, why he has justified the 226. That is the issue I want to say. If Lordship will give me 1 week time, I will satisfy before this honorable court. Why
No,
226
no, Mr.
is
Counselor,
maintainable.
these are judgments not there. No.
Because the whole transaction have been done it here, Your Lordship. Only hold the action have been done at Namru. NIT have been only issued on the mere NIT have issued on the Kolkata. It doesn't mean that it will be go for arbitration clause, Your Lordship.
There are Supreme Court judgment which says the home of the company is the registered office.
That is also in another also judgment
If it is
says
the home of the company, if he has the registered office, that by virtue of Section 20, the the jurisdiction will lie because there is one part of the cause of action there. You have to come within the ambit of ABL laminates. ABL laminate says that, look here, under no circumstance where there is no cause of action there, then the parties by their own conduct cannot fix a jurisdiction in any court. That is why I asked him, where is your registered office?
2004.
Anyways, the learned counsel appearing on behalf of the petitioner seeks for some time. List this matter. You say I may not be there from 7th of September, then you will have your luck. That's on 14th of September. Lordship.
We wanted to do this matter before your lordship, since your lordships have heard it
No.
substantially.
I may not be, although the chief has not fixed the roster. I may again appear, you never know.
We were hoping to conclude this matter.
In this matter, we have filed one affidavit yesterday, my lord. This is not an honorable court record, my lord.
In fact, so far, my lord, the officer in charge of the police station, they have also filed an affidavit, my lord, but today, I mean, so far, my lord, the assist service is concerned, my lord. I filed an affidavit.
You got the documents?
No,
This is not available with us also in the Bahan portal. That
What?
we have stated in our affidavit. The honorable court has directed us to provide the documents if it is available with us, but these documents are not available with us. That we have stated in our affidavit, madam.
So from where will you get the documents?
From NIC, I think, because all the Bahan portals, everything is handled by the NIC, National Informs.
NS?
NIC.
NIC. NIC doesn't get the documents. Somebody must have uploaded somewhere.
That case is also registered, police is investigating. They have filed also one affidavit. OC has filed one affidavit today.
Yes, what have you had? Have you moved the 175 tree?
in fact, my lord, in the affidavit, my lord,
I am questioning you as to whether you have filed a 175 tree before the
no,
magistrate.
no, my lord, because
Well,
we did not have any, no, lordship, we had filed an FIR there.
Understood. Have you seen my last order?
Yes,
We
I've
passed?
seen, I've seen.
Then what did I say out there? At paragraph number 10.
Lordship, just.
Inquired with Mr. R. Day, the learned counsel appearing on behalf of the petitioner as to why the petitioner has not approached on the 175 tree of so and so as regards the investigation being not carried out by the respondent number 4. The learned counsel appearing on behalf of the petitioner submitted that such steps can only be taken if the district commissioner provides the documents.
Now, without the documents, my lord, it's impossible.
Now, my lord, investigation is going on. My case has been registered and investigation is going on, my lord.
And lordship, if your lordship, in the affidavit, my lord, they say, the OC says, my lord, they say that they collected a document from the office, my lord, the NOC, but surprisingly, that has not been annexed. That is not on record as of now. And my lord, what has happened, my lord?
It is part of the, my lord, CD, my lord. Yes, my lord.
You should not forget.
Yes, that is so, my lord. I know, my lord.
My lord, another thing is,
I'm sorry to say,
Yes, my lord.
because yesterday I was a bit,
Yes, my lord.
but the fact remains that if the government does not file the affidavit in a proper manner, then there is no way out.
I have been informed, my lord, because this is a part of the CD, my lord, that is.
If it is a part of the record, that document will be a part of the record, then why you are not bringing it so that he can
Yes,
come
ma'am.
to know about it?
Lord, another thing, in the affidavit, it says, my lord, they are trying to nab the respondent number 5, my lord. Now, what has happened, my lord? This respondent number 5, he contested the elections from Mandia LSC, my lord, Borpeta. He got 1575 votes. My lord, he's a renowned person. It's not that, my lord, he's untraceable. But surprising, the police say that, my lord, in paragraph 6 of the affidavit, the accused is not found available at his residence and the attempts are being continued to nab him. FIR lost in
Now the
2000.
vehicle is with whom?
Vehicle is in our possession. We had repossessed the vehicle, so it is in our possession.
Vehicle is in your
Yes, my
possession.
lord. In the meantime, my lord, two transfers have been made. Lordship will kindly appreciate one thing. Now, what they do, now, what is the system as which is
Let's see
going?
the affidavit, your affidavit you have filed. You have also filed. You file an additional affidavit bringing on record that document. Ms. M.D. Bora, the learned counsel appearing on behalf of the Transport Department submits an affidavit in opposition has been filed. Mr. M. Sethi appearing on behalf of the state
Yes, the number 4.
have also submitted an affidavit have been filed. However, it is relevant to take note of that the document on which emphasis have been made in the affidavit have not been enclosed. Mr. M. Setia, the learned counsel appearing on behalf of the respondent number 4. And the respondent number 4 is directed to file an additional affidavit bringing on record the said document. This matter again on 7th of September 2026. In the meantime, the registry shall bring on record the affidavits filed by the petitioner, respondent by the Transport Department as well as by the respondent number 4. In addition to that, the respondent number 4 shall file the additional affidavit on or before 2nd of September 2026. Petitioner granted liberty to file reply if any.
The only thing, my lord, so far, thus the lordship may pass because we have filed an affidavit, my lord. My lord, the service so far the address is not found. Insufficient address is not found. Address is not found in the respondent number 5, my lord, and so far thus the, my lord, paragraph 2, my lord, we have stated that, my lord, it was received by the sister. We contacted the
By?
person by the sister of the respondent number 5. We contacted him over phone, which was
Respondent number 5 could be traced.
yes, my lord.
By you.
In fact, my lord, there's a
But
phone
he has
number.
not been able to trace
The
it.
phone number was there, my lord. Lordship will kindly come to paragraph 2, my lord, I have stated in the affidavit.
Let's see next it.
Lordship.
You provide him the information where you could trace out respondent number 5.
Lordship.
Yes, what is this?
May I please, your lordship? Lordship, in this case, my lord, this is a tender has been initiated by the Morioni Municipality Board for construction of the GPS tower clock at Morioni town. My lord, what happened, my lord? In this case, my lord, the petitioner was found as the L1 bidder, my lord. In the basis of the rate he has quoted in the tender paper. And subsequently, what happened, my lord, the respondent number 6, he was placed at L4 on the basis of the rate quoted by him, my lord. And since I am the L1, my lord, expecting for the work order, I have submitted a representation before the authority that since I am the L1, I may be granted to
You take effect service by way of dusty upon the respondent number 6. That's the only way out.
justice. My lord, as per the office note, my lord, the service has been completed, my lord.
No. Respondent number 6, you effect service. And what about this Moriani board? Their contract has been given by whom?
My lord, as per the office note,
By Moriani Municipal Board.
there is no standing council, my lord. They have no standing council.
Service is not complete against them also.
Notice is delivered to the.
Because here the problem arises, they send this thing only on 27th. 22/7.
Office,
This court have duly taken note of the office note as well as the office note, wherein it is seen that only on 22nd of July 2026, step 7, the notices have been issued upon the respondent number 3, 4, and 6. The D. Borua, the learned counsel appearing on behalf of the petitioner, expresses urgency in the matter. Considering the above, this court directs the respondent, the petitioner to effect service upon the respondent number 3, 4, and 6 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. List the matter on 2nd of September 2026. The interim order shall be considered on the next date.
Obliged.
My lord, inadvertently, I was not able to take steps within the directed time, my lord. But I've taken it yesterday, Lordship.
Huh?
But I have taken those steps yesterday. I have served a copy, and to the private respondents also speed post has been done.
No steps have been received by section upon respond number 6 and 7. Till 10-8. When did you take steps?
My lord, not in the directed time. I took it yesterday, my lord.
It has been submitted that the steps have been taken yesterday upon the respondent number 6 and 7. And extra copies, and further the extra copies of the writ petition have been served
Yes.
when?
Yesterday, my lord.
Yesterday. Considering the above, list this matter again on 25th of September 2026.
Published, Lordship.
My lord, may I pray for an early date here, my lord? May I pray for an early date here? I know.
Absolutely no. When a notice has been issued, you don't take steps. This is the consequence you have to face. Can't help you.
Published.
My lords, I appear for the petitioners in item 30.
Yes.
Please, my lords. My lords, can I take my lords to two previous orders? One is 30th April and the other is 12th May. My lords, this matter pertains to petitioner number 1 is an advocate who has suffered an egregious acid attack, actually unfortunately by a colleague advocate. Way back in March 2016, the criminal trial is ongoing. Some compensation for her medical treatment has been provided. Because of the acid attack, she has lost almost full vision of her right eye. She cannot see through that, is relying mostly on her left eye. My lords, or by orders dated 30th April, if my lords would come to paragraph 7 of the order. Please, my lords.
Yes.
Having regard, the court had reproduced in this the judgments of the Honorable Supreme Court in Parivartan Kendra, Lakshmi, as well as Nipun Saxena. And thereafter, the court directed, having regard to the aforesaid authoritative pronouncements and considering the peculiar facts of the present case, the court is of the considered view that the right of the victim to receive adequate medical care cannot be constrained by technical or financial limitations, particularly when a competent medical opinion indicates a reasonable possibility of improvement in vision. The obligation of the state in such circumstances is not merely compensatory, but extends to ensuring meaningful rehabilitation. Para 8, the recommendation of the specialist at Sri Shankar Deva Netralaya advising a repeat corneal grafting of the right eye cannot be lightly disregarded. The victim, having previously undergone treatment at Hyderabad and expressing a preference to continue treatment at the same place, such request appears to be bona fide and rooted in medical continuity. However, since the precise financial implications, logistical arrangements, and administrative approvals would require consideration at the level of the state authorities, this court provides an opportunity, and the state was to come back to the court, my lords, on both these aspects. My lords would then see the order dated 12th of May. My lord, in paragraph 2, my lords, has it? Please, my lords. Pursuant to the order dated so-and-so, my lords, I'll just read the last sentence of this, the second last sentence. This is Mr. Nath, the senior government advocate, on instruction submits that while financial disbursement may be routed through SLSA, DLSA, in accordance with the applicable framework, the necessary funds for the same would ultimately have to be made available by the state government. He further submits the state is willing, in principle, to bear the cost of the proposed procedure along with incidental expenses. However, short accommodation is sought to place the formal decision on affidavit. My lords, then again, there are some aspects of the judgment that are cited. And if my lords would come to, we had provided an additional affidavit on 11th of May, in which the expenses that she has incurred since 2020 or for the ongoing continuing medical treatment were all placed on record, as well as the proposed surgery and the possible, the approximate costs of the surgery and ancillary expenses. And my lords would just see that in para 5 again, time was sought to revert to the court, both on the surgery, the medical expenses. And my lords, I also want to draw my lords' attention that the Honorable Supreme Court, in an ongoing matter of Shaheen Malik, which is reproduced at para 4, bottom of para 4 on the first page, my lords, that the Honorable Supreme Court in Lakshmi versus so-and-so and Parivartan Kendra versus Union of India reiterated the responsibility of the state to ensure proper rehabilitation of victims of acid attack. Further, in Shaheen Malik versus Union of India, order dated 9th March 2026, the Honorable Supreme Court reinforced its stand to rehabilitation through employment of victims of acid attack and asked states to show cause as to why a direction for framing such a policy not be given. The Honorable Court also proposed that in cases that there are logistical issues in providing employment, provision of subsistence allowance may be considered. That the victim petitioner number 1 has not been provided housing allowance or government employment since the gruesome acid attack on her in 2016. This is the petitioner before my lords. She is currently paying a rent of INR 14,000 per month. That the educational and professional qualification of petitioner number 1 are given below. She has done a bachelor's of arts in political science, a law degree, and a postgraduate in human resource management. So there are the long-term issue on which the state is to revert is on making provision of employment. She is a qualified professional. How to accommodate to ensure.
Madam, what has happened in the Supreme Court thereafter? Because that is the Supreme
Yes.
Court had only suggested the state government to provide inputs.
My
But what
lords
has
is
happened
right.
in the Supreme Court thereafter?
My lords, on 2 dates thereafter, actually this issue did not come up because the court was engaged with an issue brought up by the learned amicus, Mr. Mukul Rohtagi, senior advocate, that under the Disabilities Act, Persons with Disabilities Act, where acid attack victims are also now covered, the issue of those on whom acid is not thrown, but they are compelled to ingest have not been included. So the court has on the last 2 hearings actually been engaged with that aspect. The matter is now listed in this month itself, end of this month, before the Honorable Supreme Court. But on this aspect, my lords, before this court, when I had made these submissions on the last occasion, the learned senior counsel had said that they will come back even on the issue of her rehabilitation. She is a member of the bar. Because of this, this terrible incident, she is unable to continue with the practice that she was hoping to be part of, and therefore would require some accommodation from the state.
Because the last order, as I could see more particularly on 12/5/2026.
Please, my lords.
The government advocate was to provide instructions as regards the
Yes, my
government
lords.
to bear the cost of the proposed procedure. Yes, what
Please, my lords.
Well, on 3-4 aspects, one of the instructions we have sought. Well, I have received the instructions on paragraph 10 and paragraph 11.
What about paragraph number 2 of the order of 12/5?
Well, in fact,
There was a requirement of filing an affidavit.
but in fact, I'm awaiting the instructions I'm awaiting some instruction as regard the cost because the Lordship has directed us to obtain the instruction.
What is the procedure required to be done?
Well, my instruction is, my lord, that as per the scheme in force, my lord, the maximum compensation amount of rupees 8 lakhs has been already released to the petitioner, the victim.
Okay, I'm not on that. My question is, what is the procedure to be carried out now?
A corneal regrafting, my lords. My lords, there will have to be another corneal grafting of her eye at Apollo Cornea Clinic under Dr. Rajesh Fogla in Hyderabad, which is the doctor from whom she has been taking the treatment. On both these aspects, in fact, the state has said, and it is recorded in the order, that the state is willing in principle to provide for that medical treatment. There is an additional affidavit which I have filed, my lords, dated 11th May.
The state is willing in principle to bear the cost of the proposed procedure.
Please, my lords.
Does it mention, the order does not say that it has to be specific to that particular hospital.
My lords, we just have the order dated 30th April, which I just took my lords through, which in fact records that why this Hyderabad hospital may be best for her. My lords would see para 8 of 30th April.
Yes, that is what it is.
Please, my
with
lords.
on the
And-
same lines.
And my lords, I have filed
This is
an
the
addition.
direction. This is your application, but what is your what is the direction passed according so and so appearing is granted time the feasibility of facilitating the proposed procedure at Hyderabad and the extent to which the state is willing to bear the cost of the procedure and incidental. Now, why haven't you filed this affidavit?
Malad, specifically, Malad, in respect of para 10, the two queries Malad Lordship has directed. Number one is the feasibility of facilitating the proposed terminary at Hyderabad, and number two is to the extent to which the state is willing to bear the cost. That instruction specifically I am awaiting.
No, that instruction you have already said on 12.5 that you have it, wherein you categorically say that you have it and the state is willing in principle, and you wanted to file an affidavit. Now, why haven't you filed that affidavit?
But it kindly see, Malad, along with that, the other aspects were also pointed out.
No, I
But-
forget about the other aspect. My question is this aspect where you have said that you are going to file an affidavit. 3 months have already gone by.
But on principle, because the honorable apex court orders are there, on principle, Malad, that is the spirit of the orders. But to the extent to
Mr.
which the state is
Mr.
willing, Malad,
Counsel,
that
Mr.
specific thing
Mr.
I'm
don't beat around the bush. My question is very specific. Paragraph 10 of the order of 34/2026 specifically asks you about the feasibility and how much you are going to incur. 12.5 you say that the state in principle was willing to, and therefore you wanted to file an affidavit. Now, why on earth for the last 3 months you have not filed the affidavit? My question is very specific to that.
But I have not received the specific instructions as regard the extent to which extent it will go, because
So why haven't you filed an affidavit?
But I'll file it. I'll file it.
Day after. This is the matter on Friday. File your
I'm
affidavit.
very grateful, my lords.
This is the matter on so and so on which date the affidavit which was committed to be filed on 12 by the, before this court on 12/5/2026 be brought on record.
I'm grateful.
But Lordship has fixed the,
Friday.
can it be on Monday? Malad?
No, because this is not how you do it.
Malad,
It is a very poor light. No, and she has already left. I can't help you now.
Malad, her counsel is there.
I
Malad.
can't help you now.
Inform Malad. Let
This
me
is not the
check.
way how you behave.
Malad,
Does it take 3 months? Why on earth did you say that let me file an affidavit? And don't file the affidavit for the 3 months? Doesn't look nice.
Malad, that's true.
Or you have any problem, we call the officer. Who is going to do it?
The specific,
Who is going to pay?
Malad, that is,
Who is the person who on principle said that the state is willing to bear the expenditure? Who?
but in fact,
No, you had the instruction. Who told you?
let me come up. Malad. Let me come.
Who has given the instruction?
I have received the instruction from, I have obtained the instruction from 3 departments, Malad. The Social Justice and Empowerment, Home Department, and as well as.
Chalo, we have the commissioner and secretaries present on Friday. Personal appearance on them. I'll ask them because you have not filed the affidavit.
Let me come up with the, Malad.
Affidavit.
Your Lordship, in this matter, I'm seeking some time to file the reply against the.
Okay. The learned
Yeah.
counsel appearing on behalf of the petitioner seeks for some time for filing the affidavit. Is the matter again on 5th of October 2026.
Much obliged.
What is this, Mr. Doctor?
My Lordship is a subsidy matter, my lord. The tea promotion and development scheme was brought by the tea board, my lord, in 2012 for 5 years, and it continues till 2020, my lord. And we applied for the subsidy, my lord.
We have not got it.
No, then the NOC was provided,
The
inspection was done, and we
Yes.
have done replantation, etc. The subsidy was not granted. That's the main issue.
The matter was fixed on 6/8/2026 for final disposal. Why did you take time? You took time on 6/8/2026. I fixed the matter on 10/6/2026. Pleadings being complete leaves the matter for final disposal on 6/8/2026.
I'm sorry, my lord, but
You didn't take time, sir. No urgency.
emergency is there, my lord.
It doesn't appear that the matter is urgent for which this lists the matter on
7, my lord.
7th of January 2027.
My lord, it says.
No, 7th of January 2000. I kept one word of yours, 7.
Please, my lord.
No. There's no urgency shown. Have it in the winters.
May I request, my lord, that just
7th of
one
January.
early date.
I can only do 7 because I don't have the date for the others. But 7th of January, I know it is open because of the fact the May 2026 will be the month of January 2027. And therefore, 7th of January is a Thursday.
He said too much, my lord.
Hello.
Grateful, my lord.
May it please your lordship. Lordship, in this matter, my lord, the petitioner has prayed for transfer of her deceased husband's license, my lord.
Huh?
Transfer of her deceased husband license, my lord, IMFL off license, my lord.
Oh, this
This matter.
one.
Yes, my lord.
Last time it came up before me once. This
Yes,
is the
my lord.
case.
Yes, my lord.
Where is my order? Yeah.
Yes.
There was no urgency soon.
Lordship,
Now the latest
Reply have been filed.
instruction I have received, the private respondents are not claiming for the license also.
Huh?
Now the private respondents, they're
What
even
a
claiming,
private one there.
even she is claiming for the license.
Lordship,
Unhealthy.
And as per my instruction, the premises is not even there.
Huh?
The premises is not there. The license which was issued to the husband of petitioner, the premises is not there right now.
Why?
There is no premises. The license which was issued, we issue a license against a premises, against a place, particular location. That premises
Your
is not there.
location was there, no? The
This
west side of that
GS
place
Road,
in
I think so,
GS Road.
yeah.
Huh? That was the place.
Yes.
So now what has happened? The place you have sold it.
No, my lord.
That place is given for rent for a different purpose.
So if
That
even
was
if we
done
issue,
by-
So, do one thing, well, let both the parties, both of you file a civil suit.
yes,
Lordship,
Who is entitled to the license?
yes, that because
That's the only way out. I can't help you out with.
Lordship, since my lordship may consider one aspect, my lord, since the petitioner is a widow and a housewife, my lord, she has
What
no
are you going to be do with a liquor license being a housewife?
lordship to run the business, my lord, because of, and also my lord, from the.
I think I know a lot about this case. List the matter before any other bench. Not a case which I.
Obliged, Lord.
Deeply obliged.
Yes, what is this?
Lordship, respondent number 3 filed affidavit, Lordship. 2 weeks time may be allowed, Lordship, to file our reply.
So the respondent number
3, Lord.
had filed an affidavit in opposition on 16/9/2025. The petitioner wants to file a reply. It appears therefore that the petitioner does not have any urgency in the matter for which the matter be listed on 7th of December
We have received
2026.
yesterday, Lordship. Affidavit in opposition was filed. 37. Yes,
What?
sir, we have received affidavit in opposition.
I don't know. File it on 7th of December 2026. In the
25, and-
meantime, the reply be filed.
And one reply also has been filed by the petitioner side against respondent number 3 affidavit.
Then you don't know that also. We don't have it.
Obliged, Lordship.
None appears on behalf of the petitioner on call. Considering the above, list this matter. For end of justice, this court adjourns the matter to be listed on 27th of November 2026. No urgency,
Lordship, he is terminated, his license put.
no stay.
Lordship, initially in this case, we came, your lordship, challenging certain orders, thereby debarring the EV autos from entering Dibrugarh town, your lordship was pleased to issue notice. In the meanwhile, your lordship, certain new development has taken place. A fresh order has been passed, which we have been informed, your lordship. We may have to, your lordship, challenge that order also.
Which one?
This order, just now I have been given a copy of the order.
Show me that.
No, এইমাত্র দিছি। মনি দিয়ে কইবেন।
Six.
Serial number 1, your lords.
Now your case has become on a different thing.
Lords, with this
Because
order,
earlier, EVs were not allowed.
lords,
Now EVs who are having the registered owner
Within the-
residing within Dibrugarh municipality or 5 kilometers
Lords.
radius will come in. Then
Lords.
what your case has changed totally.
lordship, that is what I am submitting. Just now I have been provided a copy of it.
And who are you?
We are the EV owners, your lords.
To your EV owners, there will be a conflict
Lordship, that is,
amongst themselves.
lordship, that is why, your lordship, I will take some instruction, your lordship, if your lordship gives me some time, your lordship.
This order was passed on 26/6.
Today, your lordship, I was handed over, just right now, your lordship.
Earlier EVs were not allowed.
Lordship. Now, your lordship, they
Now
have,
they are allowing it.
Lordship, this order, I just came to know. in the last evening.
Now EVs are allowed.
Some EVs. Yes.
Means it is not a small area. You are asking for Dibrugarh as well as the radius of Dibrugarh, 5 kilometers.
Yes. Because new cause of action arises, Lordship may kindly.
New cause of action.
lords.
Yes.
We close this with
Yes.
liberty to file.
Lords.
Because otherwise
Lordship,
some have been allowed.
Lordship.
The present petition was filed by the petitioner association challenging the action on the part of the respondent authorities in not permitting the EV autos to ply within the Dibrugarh Municipal Board Corporation and were only permitted to run within certain specified routes. It is seen that during the pendency of the instant writ petition, an order has been passed by the chairman, Dibrugarh, what is that? Dibrugarh.
Your lordship, district committee chairman, DRSC.
DRSC come District
District of-
Commissioner Dibrugarh. Whereby those EV autos whose registered addresses falls within Dibrugarh Municipal Corporation and 5 kilometer radius of the Dibrugarh Municipal Corporation boundary shall be permitted to operate within the jurisdiction of the DMC, the Dibrugarh Municipal Corporation, and Assam Medical College Hospital area. So, in view of the above, the cause of action for which the present writ petition was filed had been substantially altered. Mr. S. Botaku, the learned senior counsel, appearing on behalf of the petitioner, submits on instructions that the petitioners would be well advised to withdraw the instant writ petition and, if necessary, challenge the order dated 26/6/2026. The order dated 26/6/2026 was placed before this court during the course of the hearing, and the same is kept on record and marked with the letter X. Taking into account the said submission, the instant writ petition stands closed on withdrawal. Liberty, however, is granted to the petitioner or any members of the petitioner association to assail the order dated 26/6/2026 if so permissible under law.
Lordship, I am for Transport Department.
So and so transport department.
Obliged.
May it please the Lordship.
What is this?
My lord, this is against an award passed by the Industrial Tribunal. Award is dated.
You paid the money. Back wages.
Back wages stayed, your lord.
Reinstated.
On that.
No, not reinstated.
My lord,
This court did not under to question the reference in the proceedings on the ground that reference so did not mention the names of 12 workmen on Vaya also cannot arise. In addition to that, so and so, and the stay was granted only to the effect of accordingly this court stays the direction of payment of back wages in terms of Vaya. It is observed that there is no stay to the reinstatement. Comply?
No, not complied.
Then why should we hear? We should dismiss your petition right away.
my lord,
Not complied. Have you initiated proceedings?
We
under
have, your lordship, but due to pendency of this.
We make
case,
it
they are
very
not
clear.
used. Lordship,
We make it very clear here
Yes.
itself
Lord,
that the proceedings under 29 shall proceed against the directors of the year. The pendency of the present proceedings. And we have this adjourned cyanide till these people have put me under 20.
my lord, may I hear this writ petition, my lord?
No, please.
Now, basically, my lord, the reference was whether the management is justified in retrenching.
I have rejected that.
No, my lord.
I am only going to consider on the back wages.
Lordship, there is another point. It is pleaded. Lordship will grant me 5 minutes time to place that
No,
point. If
not-
the Lordship feels that this is not worthy, then Lordship will definitely reject
This
it.
court inquired with Mr. S. Botakur, the learned counsel who appears on behalf of the workmen as to whether the petitioners have, the respondents, whether the workmen have in the meantime been reinstated in pursuance to the award passed by the impugned award. The learned senior counsel submitted that the workmen have not been reinstated. This court further inquired as to whether any proceedings have been initiated before the learned labor court in terms with section 29 of the Industrial Disputes Act, before the learned Industrial Tribunal Assam, in terms with section 29 of the Industrial Disputes Act 1947. The learned senior counsel submitted that though such proceedings was filed, but in view of the pendency of the present proceedings, the said proceedings have not been proceeded with. This court does not find that this court have in the order dated 19/11/2025 made it absolutely clear that the reinstatement of the workmen as directed at paragraph number 34 of the award was not stayed. The only aspect on which this court had stayed was the payment of back wages in terms with the award dated 9/6/2022.
25. 9/6/2025.
9/6/2025. Under such circumstances, 22, not 25.
My lord, it is 25. 25.
Case is that 1/2012.
Okay, 9/6/2025. Under such circumstances, it is the opinion of this court that there shall be no bar on the part of the learned industrial tribunal to proceed with the adjudication of the section 29 application.
My instruction, my lord, we have not received any notice from.
Proceeded.
We have not received any notice from the industrial tribunal.
So let them issue notice, they will do it. I'm not saying that you are saying anything. They cannot stall it. Now, what do you want?
Lordship will hear this matter on it.
As regards the records have come.
Yes, records are
Record
here.
come.
Huh?
Records came.
The records being available lists this matter for final disposal on 6th of October 2026.
My lord, the interim order that is operating may be extended.
The interim order insofar as the stay to the back wages is extended till the next week.
41, I have received a set of instructions. Their representation has been disposed of by the forest department. And my lord, the scheme for rehabilitation has to be steered by my lords, the revenue and disaster management, and that we did. The district commissioners are the appropriate part, my lords, authorities. But I'll kindly have a look at this. Sina, Tinara. There was a special. The PMO office had my lord, floated a policy, my lords, for their rehabilitation.
So they will be granted 2 bighas of land, 2 kathas.
Yes. Yes. Special scheme.
Assistance for housing, financial assistance of be 35,008,000. Fixed deposit assistance to assist area of families with rupees 3 lakhs per family. With the assistance under the Iman National Relief Fund for provision of so and so. As fixed deposit for providing them a fixed monthly income for a total of 5 crores. Now, what has happened with this? This is the rehabilitation scheme.
Yes, madam. This scheme has to be, my lord, administered by the not the forest department, my lord. It has to be overlooked by the revenue and disaster management, my lord, in collaboration with the PMO.
Yes, what do you say? I've asked you also.
This it will accommodate me for some time, my lord. Let me get the
What were you doing? What was the Miss PR Mohanto doing? She was asked to find out.
Yes, my lord. Today, my lord, somehow we have, my lord, with all humility, my lord, I am submitting, my lord, we have somehow skip the file, my lord. Miss the file, my lord.
Mr.
I apologize, my lord.
Mr. D. Gogoi, we normally don't get from forest. Now the forests have become better and the revenue has gone for a toss.
Seek instructions, my lord.
Mr. D. Gogoi, the learned Standing Council of the Forest Department has placed an instruction issued by the Principal Chief Conservator of Forest Wildlife and Chief Wildlife Warden Assam to the Special Chief Secretary of the Government of Assam Environment, Forest and Climate Change Department dated 10/12/2025. In the said communication, it has been mentioned that a project for rehabilitation of 170 Hathi Fundis, bracket elephant catchers, was implemented in the Lakhimpur district, North Lakhimpur, during 2009 under Prime Minister's National Relief Fund. The government of Assam had proposed a scheme in this regard with three separate components: A, allotment of land; B, assistance for housing; C, fixed deposit assistance. The fixed deposit assistance would be provided under the Prime Minister's National Relief Fund for a provision of rupees 3 lakh per family as fixed deposit for providing them a fixed monthly income. The said instructions is kept on record and marked with the letter X. Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department, submits that that these rehabilitation is to be carried out under the aegis of the Revenue and Disaster Management Department. It is seen that on 17/6/2026, this court also directed the Additional Chief Secretary, Revenue and Disaster Management Department to file respective affidavits as to whether the petitioners herein who were engaged as Hathi Funders hole PHA and DIS funds, would be entitled to any form of rehabilitation. However, no such affidavit has been filed. Mr. Arbor Pujari, appearing on behalf of the Revenue and Disaster Management Department, seeks for a short accommodation. List this matter on 21st of August 2026. In the meantime, the Additional Chief Secretary, Revenue and Disaster Management shall file the affidavit as directed by the order dated 17/6/2026.
If I may pray, my lord, let the name of SC Revenue be shown in the cause list, my lord.
The name of Mr. Arbor Pujari, SC Revenue, be shown in the cause list.
I'm so obliged. I'm so obliged.
Yes, what is this? Hello, none appears on behalf of the petitioner on call. There's an interim order. The interim order has not been extended after this. None appears on behalf of the petitioner on call.
my lord.
Oh yes, what is this?
Uh,
You
my
know
lord, they
that
have
you
filed their
have not
affidavit,
got
my
your interim order extended,
Well, I'll pray for some time to file my reply, my lord.
but you have no interim order.
But there is interim order.
What happened last time when the matter was taken up by another court? On request of Mr. Sri N. Borwa, the matter IOC is adjourned to be listed on 12A.
Yes, we have prayed, my lord, but however, inadvertently, maybe that has
So the
been
court
left
did
out.
not grant it, and the interim order was till the next date. So you no interim order.
No.
You want to file reply. What is the interim order?
My lord, not to act upon the impugn email, my lord, dated 17/7/2025. my lord.
Okay. Hello. The learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply. Full stop. This court also takes note of that the affidavit in opposition was filed by the respondent number 1 and 2 only on 27/7/2026. Considering the above, this matter on 16th of November 2026, interim order passed earlier on 18/12/2025 stands extended till the next date. Affidavit in reply be filed on or before 10th of November. 10th of Yes, Mr. Bingo.
Lordship, here in this case, we had filed my additional affidavit where we have pointed out that the clause, that clause is 7.3.5, which is also in our annexer, page 28, your lordship.
What is the matter about?
Regarding the contractual, your lordship, I am the one of the bidder but my bidder has been not been accepted by the respondent authority, whereby during that pendency of
You have
the,
been disqualified
I have been disqualified.
and there is no stay.
There is no stay.
Then what remains?
Then thereafter, your lordship, page 28, annexure 4.
Now what happens? What remains? The
It's-
other person is working.
Yes, sir, they are working.
More than 70% work,
Huh?
more than 70% work completed.
Otherwise, your lordship, in that 11 point
If
of,
70% of the work was there and you didn't get a stay, how can I help you?
and that day, your lordship, in another case, the next point, this honorable court has point out to consider my interim on WPC 7049/2025. We'll consider on that 11 point of time, your lordship. But the matter was not decided on 10/12/2025.
Hmm.
Sandan Dingya case.
Pass the long order.
That was that order, 10/12/2025.
Gupta, so and so comply with so and so of the contract which mandated the submission of CA as well, so and so. Taking into account the submissions so made by a discourse of that opportunity should be granted, and if the petitioner was technically disqualified for non-submission of a, it is the primary view that the petitioner cannot raise any objection as regards the selection of the respondent. Yeah, consider it observed that non-passing of an interim shall not create any equitable interest in it. What is the second writ petition?
This is another successful, both unsuccessful bidders, two unsuccessful.
Same contract.
Same contract. Now, they have filed our affidavit, my lordship. In that affidavit, if lordship, WPC number.
You are the main.
104.
You are appearing for both.
Both.
Conflict of interest is not there.
Lordship.
Why?
Lordship,
No, tell me why.
lordship.
How, you see, then isn't it the case of cartel?
Lordship.
Yes, then you admit also.
Lordship, if you go, permit me to go to page 162.
No, Mr. Gogoi, the fact remains that how can you appear for both the same bidder, both the bidders?
No, there is a different bidders. So one is Sandan Ding, another is Ravi Borua.
Understood, but
Lordship.
both have participated in one contract.
They have contacted the different parties.
So therefore, how can one lawyer appear? You see, the moment tomorrow you are saying that this person is right, this petitioner is right, they have to say the other petitioner is wrong.
Lordship, only one point I want to. Lordship, if you Lordship permit me to go to the affidavit in opposition of their case, the comparative statement is mismatched.
What can I do with 70% work being done?
That is they have done tactfully they have done to give the invitation tender to the respondent number 5. They have done it that way. But my stand is that we during the
What
participant,
happened on the next date after my order? What?
they have taken time for the granting the affidavit.
Why did you allow? You should have insisted on the interim order.
I have interest in Lordship, but Lordship is not here. My stand on the point that I will hear on that point when they will give a reply.
Anyway, replies, everything are done.
Yes, everything has been done.
Well, we take it up. List this matter, taking into account the pleadings are complete, list this matter on
70% finished, Lordship. Only is. I hope only for this before this honorable court.
18th of August 2026.
Lordship.
18th? At 2 p.m. for filing this.
Lordship.
It does. Yes, mutation order.
My lord, I have received a affidavit in opposition 2 days, my lord. Yes.
Okay, the response.
By circle officer,
Alternative remedy.
filed affidavit in opposition. It has been served as my lord.
You've taken the maintainability point.
In the affidavit, it was not there. In the
Affidavit, it has not.
Huh?
In affidavit, it was not taken.
We can't help you, help the government. In spite of passing an order on 27, putting that issue, then also you don't take that point. Who on earth will help the government? Huh?
Question of law, my lord can
I may be allowed to reply. I will file counter.
Okay, Mr. D. Chaudhary appearing on behalf of the petitioner submits that some time may be granted.
Order is available order, but it's only available under 147.
But
It was passed in the year 2017, perhaps in order to get rid of the limitation factor. Madam, this is-
no, that is not the.
151 of the-
So therefore, huh?
150 and one of the-
We know it, but fraud has been committed, Melody, in this case, Melody. Earlier mutation order
Who
was.
has committed fraud?
Melody, the office itself, Melody, they did not provide us the orders, nothing else, Melody. We filed
So
application
therefore-
before the circle officer.
Go there before filing an appeal.
Yes, we can do it, my lord, provided the copy of the orders are given, my lord.
You have the copy of the order top 25, 20.
No, my lord, only Jamabandi we have submitted.
No, you have filed the order, have assailed the order dated 22/11 passed in mutation. Have you not enclosed the 22/11?
No, my lord.
Where is that?
Only Jamabandi copy we have submitted, my lord. My lord, I will give the details in my counter, my lord. I will given some time, my lord.
The respondents have filed the affidavit. Have you in that affidavit brought on record the 22/11 order?
Nothing, my lord.
What?
No, it is a part of the writ petition. Part of the writ petition, page 36. Lordship, may kindly see page 36. Page 36. Page 36, my.
Page
No, no.
36 is the Jamabandi.
That's not the order. It's a
that is not the
Jomabandi.
order.
My question is, have you brought on record the order?
No, no.
Because he has made a specific allegation that there is no, he has not been able to get the 22/11/2017 order. An affidavit has been filed by the respondents pursuant to the order passed by this court on 27/2026. However, from a perusal of the said affidavit, the order dated 22/11/2017, which has been challenged in the proceeding, and more particularly and further, there is a direction and further allegations are there that the said order dated 22/11/2017 have not been supplied to the petitioner. It was the requirement of law that the respondents ought to have brought on record the said order dated 22/11/2017. Full stop. Accordingly, this court directs the respondent numbers 4 to 7 to file an additional affidavit bringing on record the order dated 22/11/2017 passed in mutation case number. Come 8 to file over page 27/2027, not at a lumbar number. Number 2 so and so. So that said affidavit be filed by on or before 28th of August 2026. List the matter on 2nd of 2nd of September.
My lord, let the affidavit be filed by R3, my lord. He is the circle officer. Lordship has said 4 to 7 day private.
Respond number 3. Mr. Hawk, what is this?
My lord, in this case, my lord, the petitioner was issued LOA, my lord. And thereafter, my lord, he had deposited the performance security also, my lord. And other formalities have already completed, my lord. Subsequently, my lord, they had cancelled, my lord.
LOI issued.
Yes, my lord.
Then
He had submitted, he furnished the performance security also, my lord.
performance security, then they cancelled.
Then we cancel.
You got to stay.
Yes, there is a statement.
Okay, fantastic. Now you have filed your reply.
Lordship, we have done.
Why have you cancelled it?
Lordship, as per my understanding, Lordship, the pleadings in this particular case are complete and this matter is being done by Mr. P. Nayak, Lordship, Additional Advocate General. He appears in this matter. Today, because of some difficulties, he had to leave the court, Lordship. That is why I'm praying for your Lordship. Can he come on a hearing day, Lordship?
Okay. The respondents the learning coordinate bench by the order dated 25/2/2026 have, while issuing notice, have also passed an interim order Today, the counsel appearing on behalf of the respondents have sought for time. Considering the above, list this matter on finish it off on 24th of September 2026. The interim order passed on 25 to 2026 stands extended till the disposal of the writ petition.
Add two, my lord.
What?
Add two. It should be helpful, my lord. Well.
This case, my lord.
Yes, Mr. Sharma.
Affidavit will be filing shortly, my lord. That has went for vetting. And my lord, because there's a procedure, we write to the PCCF, they send us, and then it is now pending, my lord. Otherwise, my lord, the land which of the, which he claims to be, has been found to be falling under Rani Reserve Forest. Because
22nd itself, my lord, they said that affidavit has been sent for vetting. 22nd of June.
yesterday also we mailed them, my lord, so he did say that he's requesting 2 days time. my lord.
Short date may be given. my lord.
The records reveal that the respondents in the forest department have taken time on various dates for filing the affidavit in opposition. Today also, it is being submitted that further time is required. Considering the above, this court fixes the matter on 16th of September 2026. In the meantime, a final opportunity is given to the forest department to file the affidavit on or before 11th of September 2026. It is made clear that after the said period, the affidavit of the respondent in the forest department shall not be taken on record, and the writ petition shall be taken up for disposal on the basis of the materials already available on record. All of it. Would be taken up for disposal on the basis of the materials available on record on 12/9/2026. Yes.
In earlier occasion, some instruction was called for, my lord.
Directed to be clarified. Yes, what is this matter about?
Lordship, the petitioner NGO was selected for providing some training by the government, my lord.
Oh, yes.
Lordship. And
In your case is that where is Mr. SP Das? He's the main person.
No, my lord.
no, my lord,
Training is by whom?
Anganwadi workers and helpers. And
You
as
gave
per,
training.
Lordship, as per scheme, my lord, we have invested the money for.
You have filed your affidavit.
Not,
We have received instruction, my lord. As per our instruction, my lord, amount has already been paid, my lord.
To the
Then no
petitioner.
amounts due, my lord. Yes, my lord. We'll file an affidavit, my lord.
How much about?
Lordship, as per our claim, my lord, 1 crore 82 lakhs something, and they have paid 3,52,000 and something. And we have annexed the sanction letters, my lord. Page number one,
Why?
Lordship.
Is why they are saying this. They have paid something like 382. Something like 382 to you.
Lordship, three lakhs 52,000.
Because they say only this payment is being made.
Yes, my lord.
You have not filed your affidavit.
I will file an affidavit, my lord.
Mr. MCT at the Learned Council appearing on behalf of the state submits some more time is required for filing the affidavit. It may not be out of place to mention that during the course of the hearing, a statement was made that as per the instruction provided, the payment have already been made to the petitioner. However, on the perusal of the said instructions, it does not transpire that the claim of the petitioner have been taken into consideration. Considering the above, list this matter on 11th of September 2026. The respondents are granted the final opportunity to bring on record the stand by filing the affidavits on or before 10th of September 2026. Final no koribo. Another opportunity is granted.
Yeah, Lord. My lord, my accounts has been blocked, my lord, since my lord March 2025.
Your stand?
My lord, we received one notice from the Cyber Police Kerala, my lord, page 41 in my affidavit.
And
therein, my lord, we have been directed to put an debit freeze in the account, my lord.
How much?
Accordingly, we have done. my lord.
For why?
Because my lord, they say, my lord, is involved with some cyber crime. One P. Nanda Kumar, my lord,
How
complainant.
much amount?
Total amount, my lord, as per the notice is 56,23,067.60. But the disputed amount, they say it's 7,100.
Keep a lien on that.
Yes, my lord. That we can do.
It will lien kori etu kori.
All right.
May it please your lordship. Lordship, I am a rural energy technician under the Ministry of New and Renewable Energy. I have completed installation of biogas plant under the scheme of and have installed and verification and everything has been done. Over the period of time, my lord, the payment that has to be made to me, that was also made. But
Which
now,
department?
Forest, my lord.
Forest.
Huh?
Forest.
Some time is required, my lord, because the most of the works were executed in Dima Hasna and Karbi Anglong. Though they have forwarded, my lords, that they have found it to their satisfaction and the bills can be, my lord, but basic payment he has received.
How much?
No, lordship, that is not how it is. So there's a work that I have been granted. I have done that, and that payment is actual on the bills. Then since I'm a technician, over a period of 5 years, I have to provide turnkey services, and that is when I get eligible for this 1,500 amount. Now I'm eligible for it since I have this 1,500 amount. So 1820 into that 1,500 comes to that amount that I'm still due from the department. So the payment for which the initial installment, that was a different story that I got. But this AMC, we could term it like an AMC services over the period of 5 years that I have not received, my lord.
AMC?
I would, my lord, for understanding, I'm telling it AMC, but it is turnkey. It is that 5-year guarantee that I have to provide. It is under the scheme. If lordship be with me in page number 24. 24, 7.1. First line, my lord, if I may read. Turnkey job fee. The turnkey job fee is linked with 5 years warranty for trouble-free functioning of biogas plant set up on turnkey work basis. Under this, my lord, my 1,500 payment is yet pending against payment.
Yes, when are you going to get your instructions?
And this, we are pursuing it, my lords. Lordship may give me 2 weeks, my lords.
The respondent in the forest department, forest, no?
Forest.
It's granted a further opportunity to bring on record their stand by filing the affidavits on or before 28th of August 2026. List this matter on 7th of September 2026.
Hold it.
Yes, what is this non-payment?
May it please your lordship, this is an admitted matter. We have a previous order from this honorable court directing the respondents to clear the due payment. Both 51 and 52 are similar matters.
Perhaps Chief Executive Officer was requested to conduct an inquiry, my lord. Whether it's admitted or not, thereafter only we can ascertain, my lord.
There are two cases today.
Yes, madam. 51 and 52.
Huh?
51 and 52,
52
both are similar case.
Similar matter, madam.
So one case is how much? 93.
Madam.
And the other is 97. Do one thing. Verify and pay. 6 months. And the direction is to be given to whom?
Commissioner, madam. Commissioner.
Commissioner PND. Verify and pay. And nowadays I'm also adding another line in my Kalita line eta paise noy notun, that in the circumstance you are of the opinion that he is not entitled to the amount claimed, or for that matter, you are of the opinion that he is not entitled to any amount, you inform him after conducting the verification, but before the period of 6 months.
Well, in writing, yes.
Well, new type.
Or less.
Appellate order passed by the commissioner as lower assembly. You are inquired to so and so. Oh, who is the appellate authority?
Yes, my lord. Secretary, my lord.
Huh? Okay, leave the matter tomorrow for final disposal. Finish up. Because your case is for sending it, no?
For remanding.
For remanding thing to this. Because he did not decide that aspect. What was directed. I remember the case. This is the matter tomorrow for final disposal at 2 p.m. 3 p.m. To go the section. You produce that document tomorrow, huh?
Lordship, my lord, my Patalan has been running the Lokingus
What?
police watch post, my Patalan, my lord.
Filed by the respondent incorporating the detailed particulars of the land wherein Lakhiraj so and so is there. Now they are giving details.
As far affidavit, my lord, he admitted, my lord, but only for possession.
Huh?
As far affidavit, my lord.
They admit.
Admit, my lord.
Hello.
My lord, my parta land. It will take the, my lord, the location to us first.
An affidavit has been filed by the respondent number 6 in pursuance to the directions passed by this court on 29/7/2026. We can dispose it up on the next date.
Your lordship. Yes, sir.
We can. You admit to the amount.
Yes.
So are you going to a requisition or not?
Not yet done anything, lordship, because.
So let us consider it on 24th. Not for disposal, because then I have to give you the opportunity for acquiring and pay requisition. And if they don't want to acquire, then to hand over.
My lord.
Leave the matter on 24th of August 2026.
Lordship, I am for the respondents.
Personal hearing granted or not?
Lordship, personal hearing, Lordship, the SOCO's notice did not.
Mr. Counsel, where is Mr. M. Sharma?
Lordship, I am appearing on behalf of him.
You don't know. You don't have urgency then. There's a stay order operating. Why are you
Lordship,
not doing?
SOCO's, sorry, personal
I
hearing.
understand that.
Yes.
I had only inquired as to whether the personal hearing was granted or not, so that I can modify the order accordingly.
Lordship, personal hearing, we have requested to be conducted on 14/08 due to some
I asked you to complete it by 31/7/2026. Have you completed or not?
Lordship, there were some problems during that. Lordship, the petitioner did not.
Is this matter again taking into account the counsel for the petitioner is not present? Is this matter on 19th of August 2026?
May it please your lordship, kindly matter may be adjourned for the day, lordship. Mr. R. Hojamdar, mother-in-law critical condition.
Very new
lordship.
matter. What is the matter? Interim is there.
No, lord.
Lordship, the representation has been disposed of. This is a copy of the said representation.
So it's okay. So therefore, whether he's entitled to the kiss money or not. Mr. So-and-so, the learned counsel appearing on behalf of the AFDC submits that the representation submitted by the petitioner on 3/6/2026 have been disposed of. Uh, no. No. We have it on another date. Here it is said that this is no, they say that not disposed of. They say the representation have not been received. Read it properly. Why you are making that submission? Isn't it said? Second paragraph.
Yes, Lordship. And just,
What do you say? The
hence as per the-
representation of 25/7/2025 have not been traced out. Isn't it?
hence as
You
per
see
the
that?
clause. Lordship,
I can do.
as per the clause.
Hence, as per clause 23 of the agreement, you are submitted application on 3/6 for remission of the area for so-and-so is rejected. Moreover, as per the records, no representation has been received from you on so-and-so pertaining to the surrender of possession. In this connection, you are requested to submit evidence for submission of representation so-and-so. Meaning thereby, when you are saying that the representation have not been received, how can you say that it has been disposed of? Only for the remission is rejected. There is his main representation is of 25/7, where he said that I have handed over the possession.
Yes.
So Mr. P. Sharma will be better off, isn't it?
Sir.
Okay. On 7/8/2026, when the instant writ petition was taken up, Mr. P. Sharma, the learned counsel appearing on behalf of the AFDC, had submitted that the representations were submitted by the petitioner had already been disposed of. Today, when the matter is being taken up, Mr. So-and-so, who represents the AFDC, have placed before this court a communication issued by the Managing Director AFDC to the petitioner, which is dated 18/6/2026, which is kept on record and marked with the letter X. From a perusal of the said communication, it is apparent that the petitioner's representation dated 3/6/2026 was rejected. However, the representation dated 25/7/2025 have not been decided, inasmuch as it is the categorical stand in the said communication that the said representation dated 25/7/2025 could not be traced. Inasmuch as per the records, no such representation was received. Considering the above, the learned counsel appearing on behalf of the petitioner shall obtain necessary instructions in that regard. List this matter on 28th of August 2026.
Apply clause.
Effective.